anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everybody. Welcome to the session of the Appeals Court for April 3rd, 2025. There are two sessions going on today. This is the one in Courtroom 4, the Hale Courtroom. Your panel today is me. I'm Greg Massing. We've got Justice Englander and Justice D'Angelo. We have read your briefs and the record material, so we're familiar with the case. So you each have 15 minutes, no rebuttal. So when you stand up to talk to us, you can just jump right into it. And there's, like I said, you have 15 minutes, but there's no penalty for finishing early, although I think a lot of these cases today we're not going to be finishing early. So I think with no further ado then, the first case we're hearing today is 24P400, Commonwealth versus Dobson.
Good morning, Your Honors. May it please the Court. My name is Tim St. Lawrence, and I represent Sherry Dobson in this appeal. I intend to focus my argument today on the issues surrounding Ms. Dobson's conviction of the common law crime of affray, but I'm happy to answer any questions on the other issue as well. Our thesis in this appeal is that a party to an affray cannot also be the person who was placed in fear as a result of the affray, as a result of the fighting. And our thesis, the foundation of that is that the crime of affray has always been understood from its inception in England to its adoption here in America, and especially, obviously, in Massachusetts, as a crime against the public, aggravated disturbance of the public peace.
Counsel, wasn't there evidence in the record that there were other people that were at the scene, other than the people involved in the fight?
Yes.
So can't, in a light most favorable to the Commonwealth, can't there be an inference that the people who saw the fight were in fear based on what was going on?
No, I don't think that would be a reasonable inference enough to carry the weight of proof beyond a reasonable doubt. That just somebody simply being there means that they were placed in fear. You'd have to have more. You'd have to have screaming potentially might get you there, or running away, or...
Well, in knee, the court refers to, at one point, Pitt, who was involved at one point, but then as a bystander at one point, Pitt was sufficiently alarmed to tackle the defendant, wrestle him to the ground, and hold him. Isn't Pitt in the same position as the officer who actually did a similar thing? That's Henriquez, I think.
Well, I hadn't thought of it that way. You know, an officer obviously has a duty, has a public duty to intervene in the fight. So I don't think the fact that an officer saw it is enough without anything more. He testified at trial and didn't give any testimony.
Based on the video, the officer didn't get there till it was done anyway. Let me ask you this. There was no instruction asked for along the lines of what you're talking about, right? This is a straight-up sufficiency of the evidence argument.
Right.
And you say the law is that what had to be proved? That someone who was not the victim was actually alarmed or was actually in terror? What is it you want this court to say the law is?
Right. Well, I think the law, knee is the only case that has really addressed this common law crime in Massachusetts. And I think knee makes pretty clear, and it's reflected in the model jury instructions, that there does have to be evidence that a person was placed in fear, alarmed.
Right, but if as I think Judge Massing pointed out, a plain reading of knee is that the person who was alarmed was also a victim.
I don't read knee that way. So I could talk a little bit about knee because...
Well, I mean, there's another part that says the defendants and his group caused terror to Monaco, Pitt, and Marks by surrounding and attacking them.
Right. I don't think that's the holding. I think that's dictum, but because
Well, it certainly doesn't hold that the victim can't be the person who was put in
Right.
fear, right?
Certainly,
It
certainly.
seems to indicate the opposite, doesn't it?
No, I don't think it does, because I think, well, to the extent it does, it was wrongly decided, is our position. But I think the holding of that case is that Pitt, who was not a part of the affray, even though he was in the groups involved, the affray occurred when his friend Monaco was set upon by 10 individuals, or multiple individuals.
Who was it who had to go in and save Monaco?
Right, and that should,
Well, he's not
Okay.
part of the affray?
no, because at that point, he was observing the affray.
No, at that point, he had jumped on the person who was about to punch Monaco. And are you telling me that person is not part of the affray?
He may be part of a different affray, but he's not, he observed the affray, the court found he was alarmed, and that's why he intervened. So that's proof that the affray placed someone in fear. It placed him in fear of his friend getting very hurt, and he intervened. And so that was enough to show a person.
Why would the rule be what you're suggesting that it should be? I mean, if it's a crime against the public, don't fight in public such that persons are put in fear. Okay? Alarmed is the word that's used in knee. In terror is the word that's used, I think, in the statute, right? So why is it that it can't be the victim? I mean, if there used to be in this country roving gangs who would set upon people, and when they did that in public, why wouldn't that be an affray, even though the person that they set upon was also a victim?
It wouldn't be an affray. In our position is that because the fray would not have occurred without the victim, they're a part of the affray, even unwillingly. In order to have a fray, you need to have fighting.
But it's a crime against the public, right?
Right. So the victim will be, there will be a charge there. That's absolutely an assault and battery and various other charges against that victim. But now you can't add basically another assault and battery, because that's what you're doing when the victim is both the victim of the assault and battery.
That gets to your third issue as to whether assault and battery is a lesser included of a fray. But the concern with a fray is that you're doing it in public. I mean, the Alabama cases cited by your opponents say that if it's in public, it's presumptively to the alarm or terror of the public. I don't know if that's good law or not, but that's what they say in Alabama.
Right. Understood that there are, over time in different jurisdictions, it has been interpreted differently. To where I think the Alabama case was it likely to cause terror to the persons observing, to the public?
I think they say presumptively, both of them that I read this morning. I mean, it may be likely to is a better rule. I don't know. But this is an attack in broad daylight at one of the busiest bus stations in Massachusetts.
Right, but that would be reading out that the essential element that a person was placed in fear. If it was just public fighting, then all you have to prove is a fight in public. But we have an additional element, much like disturbing the peace has that additional element of there has to be detrimental impact to a member of the public from this disturbance. And so we say that it had to be someone other than...
Disturbing the peace.
Yep.
Do you have to prove up the victim? Does the Commonwealth have to prove up the victim in a disturbing the peace?
My understanding is that an essential element of disturbing the peace is that, in fact, a person has to be disturbed or annoyed by the conduct. So, and this is an aggravated form of disturbing the peace. So it makes sense that there's that element there. Not every fight in public is an affray. There is that additional piece. And that's even recognized, in the kind of the common law evolution, as we put, I think Hawkins is the first to say it, and then it's adopted along the way.
Aren't there, in the video, aren't there like some people who kind of like go near the scene and then they step back and kind of want to stay away from it?
I didn't necessarily see that. First, I would say this was not the Commonwealth's theory at trial. This was not argued to the judge on the motion for required finding, not argued to the jury. Actually, to the jury, they say it's certainly Ms. Rodriguez who was placed in fear. But putting that aside, I still don't think that gets, even if a person changed their direction but just continued walking, I don't think that's enough to prove beyond a reasonable doubt that the person was placed in fear rather than inconvenienced, or perhaps, there's even another innocent explanation for the changing of the
Well,
path.
innocent explanations don't get you out in a sufficiency analysis, right? I mean, what you're arguing goes to the question of whether alarm is the right word, which is the word used in knee, right? Or
Right.
whether something more than alarm, like terror, needs to be shown.
In knee, I think they use interchangeably. I think they absolutely use alarm. And I think they also use probably some other, fear is in the model jury instruction, I believe, placed in fear. And
That's what the jury was instructed here.
Right.
Is there sufficient evidence that someone was placed in fear from the fact that there was a pretty serious fight going on a street corner? I mean, I saw several kicks to the body and several people around, one of whom did appear to change direction. Isn't that sufficient evidence that someone was placed in fear?
Our position is no, that doesn't rise to the level. Now, somebody intervening, like in Pitt in knee, or running away, or testifying that they were placed in fear, I mean, that proof beyond a reasonable doubt, no, I don't believe that would be sufficient. A person essentially changing their path, but not showing any other indicia of fear would get you there, would get you over the bar.
I don't know. I was waiting for the bus the other day, and a guy was, just kind of walking along, shouting, and and everybody kind of, tried to stay away from this guy because you didn't know what he was going to do. And would that be sufficient fear? I mean, if he was two people. I mean, would that type of reaction be enough?
It's difficult to do it on, I would suggest to the court, on body language alone. It is difficult unless it rises a little more than kind of a stepping back, or, that's our position anyway, is that otherwise you're just really taking that element out and saying, was a person present? They're in fear. I mean, because it's just too close. Without a little bit more.
Well, a little bit more, meaning what? Meaning that you have to put them on the stand and have them say, I was afraid? In other words, are you saying that a person has to be identified and proved up as having been fearful?
That would be the easiest way, but of course you could have, if you have a video of someone sprinting away, or audio of the person screaming as they're observing the fight, that I would probably submit would be enough to get you over the...
And you say that something like that is needed for disturbing the peace? It's not enough that, somebody's, I don't know, standing in the middle of a common area among a bunch of buildings, screaming at the top of their lungs and banging a drum in
No.
broad daylight, and that can't be disturbing the peace without putting somebody on the stand who says, "Oh, I was disturbed by that."
No, I would concede that, but
Well, if
you're
you
talking
concede that,
about
then-
disturbance versus fear, okay? So to prove disturbance is easier, I would suggest, than to prove fear. So the actions themselves a reasonable person could say, yes, these actions that this person was doing, and there were people present, those people were a rational fire check could find disturbance beyond a reasonable doubt. But fear, I don't think so. That's our position.
So that goes back to my very first question, which is, if in the disturbing the peace you can infer that based on what we've seen in the video where we see people stepping back in a light most favorable to the Commonwealth, why isn't there an inference that they were in fear of what they were seeing?
Because it's too hard to read that body language to equal fear. It could equal a lot of things, including inconvenience or fear.
We have to look at it in the light most favorable to the Commonwealth.
In the light most, our position is no, that absolutely is not enough. That would essentially be reading out the essential element that a person be placed in fear. Not just that a person's there and might,
No, okay.
Yeah.
I think, any more questions? I think we
I'm
understand
over
the
time.
point.
Okay,
Yeah.
thank you.
Okay, thank you. We'll hear from the Commonwealth.
Good morning, Your Honors, and may it please the Court. Charles Marshall on behalf of the Commonwealth, also joined by the trial prosecutor, Max Robidoux. I'll start by addressing what was Your Honor's chief concern and counsel's argument, that being the challenge of the affray charge. But I will first start by saying, and I believe Justice D'Angelo indicated this with the first and last questions, that issue, at least in the way that it's been framed by the defendant, is not determinative in this case. And that is for two reasons, essentially, that the panel indicated. One, there is sufficient evidence that there are plenty of other people in which that fear could have been presumed, aside from Ms. Rodriguez, who herself was set upon during the affray. We know that from Detective Enriquez's direct testimony, as well as the video. First, the video is the clearest and most helpful part of that evidence. It shows that, again, as Justice Englander pointed out, this is broad daylight in August at 7 o'clock across one of the busiest bus stations in Boston. There are several people, moderate foot traffic, walking around. There's also moderate vehicle traffic.
All true. What does the Commonwealth think they have to prove affray?
So, Your Honor,
You use the word presumptively in fear. I saw that in the Alabama case. That leads to the hypothetical about the people who are in the parking lot at 6 o'clock on a Sunday morning behind a convenience store, and whether, because they got in a fight, they committed an affray. Did they?
So, Your Honor, this is something counsel said on answer, was that not every fight in public is an affray. I would agree with that to an extent. I think there are three elements. Those last two, the case law talks about how they are interrelated, but they make clear to distinguish that they are separate. So I do think that there needs to be a fight, and I'll point out to the court that the jury instructions and knee make clear that it doesn't actually have to be a physical fight. That's also relevant to counsel's third argument. There needs to be a fight. It needs to be in a public place. I think both of those are clearly satisfied, and counsel's not challenging those.
Yeah, but what do you have to prove? You have to prove a fight. You have to prove a public place. Do you have to prove anything more?
I think we have to, the only other thing we need to prove.
I heard you say not every fight in a public place is an affray. So what else do you have to prove?
I would say that the additional fact that we need to prove is that at least one other member was in the area, in the public at that time of the fight. And then from there, the case law makes clear that that fear can then be presumed or inferred, and we don't have to offer any direct evidence of the fear itself.
Have to be, quote, in the area, which means it has to be proved that they witnessed the fight?
Correct. I think most of the out-of-jurisdiction case law that we see where this question is asked and where they determine that it wasn't actually an affray are these situations where, yes, it might have been a public place. I believe there's one case, I can't remember the jurisdiction, where there's a fight on a highway, which presumably is a public place, but it happened at night when there's no road traffic, no one else was around. So I think that's a good distinguishing characteristic from what we have here. I do think that there does need to be at least one person present, and then from that, the jury can reasonably infer that that the person who we proved was present for the fight was placed in fear.
14-year-old kids in a high school. They're mad at each other. Let's meet outside, have a fight. Their friend is present. They have a fight. They've committed an affray. No one else is there. They do it, after hours. They make sure nobody else is around, except, their buddies there. Is that an affray? Does he have to be in fear?
He being the friend?
Yeah. Not in fear, because they're two 14-year-old kids, and he knows what's going on.
I think he would have to be in fear. And I recognize that that's a unique situation where
Guys
potentially...
on the hockey rink. They fight all the time. They committing an affray, there's 18,000 people present.
I think that's correct. And while I don't necessarily... I see the distinction that Your Honor is pointing out. I think that's obviously not the case that we have here.
I understand that you would say that, although your brother argues that the evidence in the video does not show it. But that gets us into, just simply the questions of the sufficiency of the evidence for purposes of a Lattimore analysis. But defining the crime seems to me to be a little harder than one might think, right? You have a statute that uses the word terror. You have a case that uses the word alarm. And you have a whole lot of hypotheticals where you get like a range. So what do you think the answer is?
So what I think is helpful, in the knee court, Justice Grasso's opinion points this out quite a bit, and Your Honor's hinted on it a bit. The most akin crime that it's compared to is disorderly conduct and disturbing the peace. And as Your Honor's pointed out, in those instances, similar to what I would suggest the plain language of knee and the jury instructions here indicate, is that it just needs to be likely to instill some sort of fear to prove disorderly conduct or disturbing the peace.
But that's not what the jury was instructed on in this case. And it wasn't argued by the Commonwealth, which gets to a point, but I want to stick with Justice Englander. What evidence does the Commonwealth need to put forward to get to that at least one person who was lawfully present in the public place was put in fear? That's what the judge instructed on, which we'll get to in a moment. But what was there in this case? Is it the stepping back that we've all seen in the video?
So I see that as two questions. What was there in this case, and what needs to be proven in a broad spectrum if the court is inclined to further narrow what exactly is the phrase? In this case, we have ample evidence. We have, first, Detective Henriquez was there he was not called to the scene. It wasn't a 911 call. He was there doing surveillance for a completely separate investigation. He was alarmed enough to see this and rush over and help. There was also testimony. He did not testify himself, but there was testimony that there was a Detective Walsh. He can be seen on the video coming to aid as well. Additionally, and I pointed this out in my brief from the video, you can see two people in particular. One individual is walking down Harrison Ave towards, I believe, Warren Street is the intersection where that affray is going on. He walks by that intersection directly as this affray is happening. He crosses the street. He stands outside the bus station for approximately, I would say, about 8 to 15 seconds. And then when police intervene and break up the fight, he continues back on that path to the intersection and continues down that intersecting street. I would suggest that that is a strong, reasonable inference that that person was in fear. He did not want to continue on his route of travel. He broke from it. When it subsided, he went back. There's also another woman that can be seen coming out of Nubian bus station. She does something similar. She looks across the street. It looks like she goes to cross. She sees the affray. She doesn't continue. She waits. It subsides. Then she continues down.
The element is they have to be put in fear?
I apologize, Your Honor.
They have to be put in fear? There has to be a reasonable inference that they were put in fear, or is it that they were alarmed? Judge Grasso uses the word alarmed.
And I recognize that a lot of the older precedent uses terror.
And the jury instruction used fear.
Yes. And that's a discrepancy that I can't myself resolve. I would suggest that fear, based on how they were instructed, is what the jury needed to find.
So the judge didn't explain them what fear meant, right? I mean,
No, and again, there was no request for
would you
further
say
elaboration.
is it an aggravated version of, so is it something more than disturbed?
I think just on plain language, I don't have any case law to support that it is, but on plain language, it seems to be different from being disturbed. I think the relevant cross-connection between those type of charges is more the presumption of fear or the presumption of someone being disturbed rather than the actual definitions of what the person is instilled with.
On this topic, before we get to Justice D'Angelo's question about can we actually consider this guy, Officer Enriquez, I'm thinking it's in indecent assault cases, not indecent, like lewd and lascivious. Can the police officer be the victim? Isn't there a recent case on that? It's either indecent exposure or lewd and lascivious, and somebody's got to be alarmed. And can it be the police officer who makes the arrest?
So if there is a case, Your Honor, I'm not aware of it, but I would say that it would probably depend on the factual circumstances. If he was called to the scene and then finds him there, I would suggest probably not. But if it's a police officer, say an MBTA transit officer, where a lot of those crimes tend to take place, if he is just in the station and sees it himself with nobody else around, I would say that yes, that officer could likely be considered the victim, for lack of a better term. But again, I think that's a crime against the public as well, where I wouldn't necessarily describe him as the victim, even if he himself was the one who suffered from it.
Now, can we get to how the case was actually tried in the district court? Do you now concede that it can't just be the people involved in the fight who are in fear, and it has to be a member of the public or maybe the officer? Because that's not how it was tried, and I don't think that's primarily how you wrote it in your brief.
So I would not concede that, Your Honor, and I don't think that there was any problem with the trial prosecutor arguing that because of the decision in Knee. I think Knee makes definitely implicitly, potentially explicitly, true that someone's set upon during an affray just because they were involved to some degree, and Ms. Rodriguez here was far less.
Is every single fight then an affray?
So long.
You can assume that at some point during the fight, unless it's the most mutual combat ever, somebody gets in fear when they're getting beat upon. So every fight's an affray, if it's in a public place.
So I think I'll stop short of saying that every single fight, so long as it's in a public place, is an affray. I think what's important, and I think what is similar to Knee and here, is when an individual is set upon by other individuals. Whereas it's not, and Knee makes clear that there doesn't need to be consent. No one needs to prove a consent in an affray on either side. They could be agreeing to meet up to fight. They could be on opposite sides. They could be on the same side. But here, like in Knee, when someone is set upon, who is set upon, and then there is direct evidence, and there was direct evidence in Knee, and there's direct evidence, at least from Detective Enriquez, that Ms. Rodriguez was scared. She was near the verge of tears. That in situations where someone is set upon, essentially jumped, for lack of a better term, that is a differentiating characteristic from just two people, say, to go back to your example, Justice Engler, of two kids fighting in the back lot of a parking lot with maybe some kids that are watching. That's a different situation entirely. And if Your Honors are inclined to narrow this definition and separate those two circumstances, I think that would make sense.
I don't know that we're inclined to do anything at the moment. We're just trying to figure out what the crime is. And, there's one case on it in 100, 200 years, whatever we got. I've been sitting here thinking about Judge D'Angelo's question because it strikes me that you have potentially two components to this. One is that someone has to be put in fear or alarmed in some way, and the other is that it has to be public. And I'm not sure that you can get a fray simply from saying the victim is the person who was put in fear, because you have to show, it seems to me you've conceded, and I'm not trying to put word, but I think you have to show that someone from the public either was or could have been aware of it, reasonably could have been aware of the fight. And if you have to show that, don't you have to show that that's the person who was alarmed or put in fear?
I don't necessarily think that you have to say that a single person was put in fear. I think, again, going back to the fact that this is a crime against the public, if there are multiple people present, I think that we can put forward sufficient evidence that any one of those people can be presumed to have been placed in fear, and then I think it's an issue for the jury. To go back to your earlier hypothetical about these two schoolyard kids where one friend is present, while maybe a jury could reasonably find in their deliberations that they cannot go so far to find that person was placed in fear, I think at that point there would be sufficient evidence to at least get over a directed verdict and submit it to the jury, and at that point it would be the jury's prerogative to essentially determine whether or not they can find that person was placed in fear.
But if one member of that fight, who's probably the loser of the fight, gets scared during the fight, then it isn't a fray. Even if the bystander's not scared, if the victim, we'll call him the victim because he's losing the fight, he gets scared. Under your theory, that's an affray.
To bring it back to the Lattimore standard, analyzing it under the Lattimore standard, yes, I think that person could be found to have been the member of the public put in fear.
The judge, and again, there's no model instruction, so I credit the judge for coming up with an instruction, probably using me, says at least one person who was lawfully present in the public place. Do you think maybe that means a bystander as opposed to the two people who are fighting?
I don't, because I think Knee addresses that point directly. In Knee, the challenge from the defendant was essentially that Monaco, Pitts, and Marks were not people lawfully there because they chased them into this park. The Knee court discredited that and found that, no, they were in fact people lawfully there. So I don't think that that's a distinction.
Well, it's interesting, the statutory form for this crime is, and it was reflected in the complaint, that the defendant did make an affray with Sal Rodriguez. Like, it is, the defendant and Rodriguez are making the affray.
That is correct, but as I would point out, and as your honors know, the complaint itself is not evidence and was not submitted to the jury. And I see that I'm out of time, so unless there are further questions, I'll rest on my brief on the remaining two issues.
Thank you both. Really interesting case that's submitted. Yeah, good job. Second case for today is 24P864, Commonwealth versus Jose Shaw.
Good morning, and may it please the court. Haley Jacobson on behalf of Jose Shaw. I briefed 3 issues in this case, and I'd like to focus on the first and last of those issues, the authentication issue, and whether Section 10A requires knowledge of the licensure requirement. Excuse me. Turning first to authentication, I think this issue is actually quite simple. All of the authentication, all of the self-authentication provisions that could possibly apply here require an attestation.
I'm glad you think it's easy, because I certainly don't. Let's start with what from your view, does attested to even mean?
So I think the SJC has made that clear in Daramo, I'm not sure how it's pronounced, and they quote Black's Law there, as well as a DC District Court case, to say that an attestation is a written and signed certification that the document is a correct copy. And there is nothing on this document that certifies that the signer compared the document with the original and that the copy is a true and correct copy.
I want to break it down a little bit here, because there are 3 things, I think. So the seal, which embalmed seal, appears on every one of the documents that was admitted into evidence. So your argument, and I'm sure the Commonwealth may have a different view, the seal itself is not an attestation.
Yes, that's correct.
Okay, now I think it's on the first few pages of the exhibit. There's a signature on a couple pages where there's a seal. That's not good enough from your perspective.
Yes, that's correct. Neither the seal nor the signature certify that the signer compared the copy with the original, and neither of those things certify that the copy is the same, is accurate as to the original. And I think we can look to the statutory and the language of the rules as well to know that an attestation is more, or an attested copy is more than a signed copy, because if a signature or a seal were enough, then the statute and the rule would say a copy signed by the officer having legal custody of the document. But it does not say signed, it says attested. And so to give meaning to that language, it must be something more than just a signature. And the SJC has, in fact, as I mentioned, made it clear what the attestation is, and here there was none.
I don't want to foreshorten the interesting argument about this, but presumably before the second part of the trial, the Commonwealth shared with the defendant the exhibits it planned to use, and when they were introduced in evidence, there was no objection. And the reason we ask for objections is so that things can get fixed. So to show you've got a substantial risk of a miscarriage of justice here, don't you have to show there's some possibility that this is an error? That he wasn't really convicted of this crime?
I don't think that Mr. Shaw needs to show that the document admitted was inaccurate or has inaccuracies. I'm not aware of a case that requires that. The question on a substantial...
Yes. Go ahead.
The question on substantial risk is whether the court is persuaded that the error did not materially influence the verdict. And the error here is admitting the unauthenticated docket. And admitting that unauthenticated docket undoubtedly influenced the verdict.
Stop. So I get what you're saying 100%, but I disagree, and so you're going to have to convince me. I don't think there was an error where there was no objection. Unless you can tell me somehow you got something that suggests that a judge, when the other side is stipulating to the, or essentially stipulating to the admission of an exhibit, has committed an error.
So, well, first I would say that the defense counsel did not stipulate to the admission of the document. I don't think the lack of
They didn't object. In any trial I've ever been at, I've been at a few, granted, not a whole lot of criminal trials, but in every trial I've ever been at, when you don't object to an exhibit, you've stipulated to its admissibility.
Well, I don't think I would agree with that, but even still, the question...
But that's a huge, that's essentially the question that Judge Massing is asking, because the problem, of course, is what he just said. If nobody alerts the judge to the question of whether there's an issue, or alerts the opposing party to the question of whether there's an issue, then the opposing party doesn't know, geez, maybe I ought to go find the other document.
So I think both to your question, Your Honor, and to Justice Massing's question, what the court is perhaps doing is speculating about what might have happened had counsel objected. And I think that's an understandable inquiry, but I don't think we can know that the trial judge would have, in fact, allowed the Commonwealth to fix this mistake, to go to another courthouse to get the correct document in the middle of trial. In fact...
But you're the one who's assuming they don't have it sitting in their file.
Well,
I mean, we don't know any of this because the defense counsel didn't say, and also, as Judge Massing points out, often this is done before trial.
I think a couple of points. I think we can presume that the Commonwealth did not have a correctly certified copy in their files at trial, otherwise presumably they would have admitted that their correctly certified copy. And I also, just returning to my earlier point, I think it's certainly possible that had counsel objected, then the trial judge would have excluded the evidence because it was improperly certified. It was not authenticated, and the trial had already begun. And there's no evidence in the record that the parties had discussed this evidence or stipulated to it prior to the beginning of the sentence enhancement trial. And so I think ultimately the question...
But the thing is, of course, we're speculating because we don't know, because no objection was made. Now, Judge D'Angelo would probably have much better perspective on what would happen in a district court trial than me if the objection had been made and it turned out that the judge thought that there was a problem with the exhibit. But, geez, I've seen trials, stopped for a short period of time, or, we'll have a recess so that we can prove this up.
Yes, and I think that certainly could have happened, but we can't know for certain. And it's also, I think, equally, if not more plausible, that the judge would have sustained the objection and excluded the evidence, which would have resulted.
I'm going to agree with you that not objecting is not a stipulation. And perhaps defense counsel could have argued in closing that even though it came in, the jury should not consider it because it didn't have a signature, blah, blah, blah. But that wasn't done either. So even though I agree with Judge Massing, it's a good intellectual argument, and I'd love to go further with you, help me out on why it's a substantial risk of a miscarriage of justice.
I think ultimately the answer to your question is that the document should not have been admitted, and because it was admitted, that is the reason that Mr. Shaw was convicted. It was
In Duramo, which I am very familiar with, there was an objection, and the SJC highlighted that. That's a big difference than here.
Yes, I agree with that. I think this case is quite different from Duramo. However, I don't think that the lack of an objection means that nothing in that case is relevant to this one. I think the requirements of an attestation and the court's point in that case that those requirements must be rigidly adhered to, I think that still applies even though the standard of review here is a substantial risk.
I do want to get to your third argument, but I just want to make it clear. So you feel that attested to means there has to be an affirmation, a signature that also says this is a true and accurate copy?
Yes, that is correct.
Okay.
And I think, yes, so that is the position.
Now let's get to knowledge. Your basic premise, I guess, is that Guardado is now making the law that the defendant also has to have knowledge that he needed a license to carry a firearm?
That's correct.
Why?
So I think there's a number of reasons why, both based on ordinary statutory interpretation principles, but also based on constitutional avoidance. So first I just want to emphasize that the statute before this court is not the same statute that was before the SJC in Jackson, and that's because 10A has been amended legislatively since Jackson to add that word knowingly. So in terms of just the plain statutory interpretation question, the question is whether that word knowingly applies to the licensure element. And I think the best reading of the statute is that it does. We ordinarily presume that the word knowingly at the beginning of a list of elements applies to every element. And here, that word knowingly already applies to the two other primary elements of the offense. The possession has to be knowing, and there has to be knowledge that the item is in fact a firearm.
The legislative language that you just talked about that was changed, that was in effect in Commonwealth versus Marrero, wasn't it?
Yes, that's correct.
So they pretty much and I know it's pre-Guardado, which I want to get you to, but they pretty much did away with your argument. They said knowingly doesn't apply to whether the defendant knew it was against the law.
Yeah, so I would disagree that that Marrero dispenses with my argument. I think Marrero forecloses the argument that knowingly applies to the facts that make a firearm under the statutory definition. And I think that the court almost made an exception to that presumption that knowingly applies to all the elements of the statute for reasons that are specific to the statutory definition of a firearm element. And they mentioned the fact that it would be unworkable to apply that knowingly mens rea to the facts of the that make it a firearm, which is, I don't think, the situation here. They also distinguished Cassidy where they relied on that presumption by saying that in Cassidy—
I don't think they called it a presumption. I think the way to lay those two cases, because that language is just it's sort of the beginning of the reasoning in Cassidy. I think the way to lay those two cases next to each other is we're going to construe the statute in each instance as to whether we think knowingly applies to a particular element. Isn't that the fair way to read those two cases together?
Yes, I think that's correct. And I think—
Yeah, no, so what, I mean, I just want, it occurred to me that, he was not, there was no instruction about knowingly in terms of the licensing. But is it knowing, does he have to know, in your argument, does the Commonwealth have to prove that the defendant knows that he didn't have a license or that he had to get a license?
I think that they're more or less one and the same. In order to know that you don't have a license, you need to know that the requirement exists. So I think the argument that I've made is that the defendant needs to know that there is a licensing requirement, that you're required to have a license. I think that is more or less the same as knowing that you don't have one. You have to know that there is a requirement to know that you don't meet the requirement.
One of you put in your brief, and I apologize, I don't remember which, in a footnote, the old axiom of ignorance of the law is no excuse. So you're really bootstrapping that and saying, no, you do have to know that it's against the law.
Yes, and while that maxim is certainly well known and well cited, it is actually not universal, and the Supreme Court has numerous cases where they make exceptions to that, or not even exceptions, but clarify when that rule applies and when it does not. And where it does not apply is where there's some legal matter that makes, there's some sort of collateral legal matter that makes the defendant's conduct a crime. And that was the case in Liparota versus United States, where the Supreme Court said the defendant had to know for the food stamp fraud statute that their use of the food stamps was not authorized by law, because it was the fact that the use was not authorized by law that made the conduct a crime. And again, here, it is what the licensing statute, or the licensing requirement now, is what makes possession of a firearm a crime after Guardado. And so, as in Liparota, as in Ruan versus United States, where the defendant has to know that the dispensation of a controlled substance is not authorized by law, here the defendant needs to know that there is a licensing requirement and that he doesn't have a license, because that is what defines the criminal conduct here. That is what is the defining line between lawful conduct and unlawful conduct.
Can we talk a little bit about the procedural posture? I'm sorry, did you have a question?
Go ahead.
So this is not an objection to an instruction. This is not, I requested an instruction that they had to know this and they failed. So it's a sufficiency of the evidence case, right?
That's correct, yes.
And you're relying on the principle that we have that's automatically, if it's not proved, it's a substantial risk, right?
Yes.
Why isn't there sufficient evidence here that he knew?
Why is there not sufficient evidence here that he knew? I think that
and let me just suggest to you that if a guy runs from the police after firing a gun in the air, and then just as the police are getting near to him, he drops the gun on the ground and then jumps over the fence, a jury could infer that he knew he wasn't supposed to have that gun.
Well, I think the reason that is not the case was in Your Honor's question, which is the fact that he had discharged the firearm. And I certainly think it is equally plausible, if not a more plausible inference, that any consciousness of guilt was as to the discharging of the firearm and not necessarily as to knowing that he was not permitted to have
Back to where we were in the last argument, which is that we don't have to indulge in, in reasonable constructions of the evidence that go in favor of the defendant. In fact, we're required to take all reasonable constructions of the evidence in favor of the Commonwealth on a sufficiency argument.
That's true. However, where there are two inferences that are equally plausible, that is not
What
sufficient
about the
to-
statements he made afterwards?
Well, I think if
Those
anything,
also indicate consciousness of guilt?
I think the statement that he made when
Of
asked
a license, what's that?
I think if anything, that shows a lack of knowledge. I realize that the Commonwealth argued it the other way, but I think the reasonable inference there is that what does that means I don't know what you're referring to. And certainly that doesn't show that he
Can't
did
take
know.
that together with the fact that he dropped the gun as he was jumping over the fence?
No, because I think in order to take it together, the statement when the police officer asked about the license would have to there has to be a reasonable inference from that statement that it is consciousness of guilt or it is awareness of the licensing requirement, and here I don't think it is. I see my time has expired, and if there are no other questions, I would ask the court to vacate. Thank you.
Thank you.
Good morning. If it pleases the court, Arne Hansen from the Commonwealth. With respect to the licensing issue, I'd like to address a practical matter here. If the court were to adopt the defendant's proposition that we would have to prove that the defendant didn't know he had a license, we're essentially decriminalizing illegal possession of a firearm, because any savvy defendant would have to say upon his arrest, I didn't know I needed a license. That would bar the Commonwealth.
That overstates it for the reasons that we just were talking about. I mean, there's lots of reasons that they can know about it, in fact, including that they've been arrested for it before.
Correct.
So it doesn't decriminalize it. It just makes it harder to prove.
Which is fair. Now, with respect to whether or not we had to prove that he knew he had to have a license. I think it's clear from the statutes, the way that the jury instructions are written, as well as the case law on this point, that it's not the way that that should be interpreted. With respect to the actual statute itself, it's very clear that the plain language in the statute places the knowingly only on the possession element. And we know that because there's two ways to possess the firearm. There's the constructive possession inside the car, and then there's the possession on your actual person. Knowingly qualifies both of those conditions. It does then not apply to the subsequent elements, which are functional firearm as well as licensing. And we also know that it doesn't apply to functional firearm because that's exactly what the court addressed in Marrero or the SJC addressed in 2020 in Marrero.
Which one are we talking about? This is 10A?
Correct.
Next case is 10M.
And the no
Now,
kidding.
if we look at the jury instruction.
I don't mean to.
Oh, I'm sorry.
I'm trying to, so 10M says,
10A.
10A says, knowingly possess, knowingly have in your possession a firearm without either having in effect a license or having complied with the provisions of. Right? So that you have to knowingly possess a firearm. The problem that was addressed in Marrero was firearm is further defined as being something less than 16 inches in length or something like that, and they said, well, you have to know exactly what it is, and the court said no, right?
Correct.
So you say the only thing that knowingly modifies is possession. I didn't understand your point about it could be actual possession or constructive possession. I was looking, is that in the statute?
I think when I say that, I was referring to a specific case, which I don't have in front of me right here, but it's either.
Well, it's
I
either
think-
knowingly has in his possession or knowingly has under his control in a vehicle.
Yes, so that's what I was
see.
referencing.
So it's
Okay.
knowingly
All right.
for those two. Now,
Okay.
let me ask you, the Supreme Court has now said that someone has a constitutional right to bear a firearm. So you would agree that our state can't just arbitrarily say you can't possess a firearm?
Correct. Are you referring to the Bruin decision?
Yeah.
Yes, but Bruin also upholds the licensing scheme. So it says there's nothing wrong with a state imposing a licensing scheme before an individual gets a firearm. The qualifier is it should be shall issue versus, which is more of it takes the choice away from the state. If there's no reason not to give them a firearm, or license, they should be handed a firearms license.
So why shouldn't the defendant's argument that you have to knowingly prove that he needs a license flow from that?
I think
Ignorance might be under now. If you have a I agree that a state can prohibit it for various reasons, but if you have a constitutional right to bear a firearm, why isn't it only criminal if you prove he knew that?
So I'd like to qualify that not everyone has a constitutional right to carry a firearm, and Bruin, as well as McDonald and Heller, all stated that this right doesn't apply to convicted felons, and Bruin specifically upheld that it doesn't apply to convicted felons, which the defendant was in this case. Additionally,
But they all started out with a constitutional right to bear a firearm. I don't mean to be too combative about this, but I don't think that's an answer to Judge D'Angelo's question. He's really saying, look, where there's a constitutional right at stake, and we now know there's a constitutional right at stake, which the government has the power to regulate by requiring you to get licensed, okay? Why isn't an element of the crime of possession without that you had to know that you should have had a license? That this license requirement is a take back on the constitutional right that everybody had when they were born, if they're a citizen of the United States.
right, I think what we're dealing with is ignorance of the law, and there's a distinction here. Ignorance of the law applies to due process rights that affect passive actions versus taking an active action. So if you look at the Lambert case, so Lambert v. California, that was one where a city in California had a law that required convicted felons to register. And just being a convicted felon in an area and if you didn't register, you would then be violating that law. And they found that that right was unconstitutional because it's acting by omission. You're not doing anything active to go out of your way to break this law. You're just present in the city.
Counsel, I think as I'm thinking about that principle, it does seem to me to go too far. So let's take the last argument, disturbing the peace. Oh, I didn't know that it was illegal for me to, to stand in the middle of a square and bang a drum and scream at the top of my lungs. And I have a First Amendment right to do that because I'm speaking. Wouldn't matter that it's a First Amendment right. I don't think you had to know that you were violating the law of disturbing the peace, right? That would be the Commonwealth's position, at least.
Yes, I think that's fair.
Yeah, okay.
If you're convicted for failing to register as a sex offender, do you have to know that you had to register?
Yes, but I think convicted sex offenders, when they are convicted, they are informed that they have to register.
I was reading the cases that were cited by Attorney Jacobson in the 16L letter. The Ruan case says that the criminal law punishes conscious wrongdoing. So the government must prove that the defendant knowingly acted in an unauthorized manner. So why is this different from, say, the using the EBT card in the wrong way, in that case it had to do with prescribing drugs?
Well, here we're dealing with an individual that has been previously convicted of carrying a firearm without a license, so he certainly knew that it wouldn't.
But suppose he wasn't.
I think this is distinguished conduct because you can't just walk into a gun store and buy a gun. If you walk into a gun store, I don't think they'll hand you a firearm without asking you for your license first to make sure that, one, you are qualified to even handle that firearm.
And that might be a good way for the Commonwealth to prove that somebody has to know they need a license. But that wasn't presented in this case, nor do I think it's ever presented something like that where you get somebody from a gun shop. You're resting on the inference that just having the gun alone, that's knowingly.
Correct. Now, with respect to the defendant's first issue, this was clearly an attested to document. It came from the Brockton District Court with the seal of that court, and it was signed by the clerk magistrate of that court.
Not every page.
Correct, only the first 5 of the 9 pages.
In fact, the part that talks about the conviction where it was guilty was not signed. So is the seal enough alone?
Yes, and so if you look at Duramo and Babcock, so Babcock, which is a 21 case out of this court, says the clerk is the official custodian of the records of the court. The seal of the court attached to his certificate attests to the authentication of the records. So it'd say that his signature is the certificate, or is the certificate where he attests that these are official copies. The other side of that argument is that the defendant hasn't demonstrated prejudice, which Duramo clearly states.
Let's stick for a moment with what actually the law is, because somebody up here is going to have to try to figure that out. You say, and your opponent disagrees, that merely having the seal of the court is sufficient attestation, and that our case law says that.
Yes, so if you look at...
And when you talk about a seal, are you talking about a raised seal?
Correct, which was on this document.
We know this is a raised seal because all I have is a copy.
We would have to get the original from the Brockton District Court, but not from the Superior Court now.
It looks, if you look at the first page, it looks like it's raised. Let's for a second assume that all the pages have the raised seal. I want you to distinguish, because I think there's 3 things the defendant raised is. 1, does an attestation mean somebody says, probably the clerk, true and accurate copy? That would be 1. Number 2, just the seal alone. And then number 3, a seal with a signature. Because in this case, like I'm trying to focus you here, the first couple of pages have seal signature, but then a few pages later, all it has is the seal for some reason, not a signature. So which is it?
So it's a seal that is attested to. So my argument here is that his signature is attesting to the document. I understand that there's an issue here where he didn't sign every single page of the document, and I have no real explanation for that other than he didn't want to sign every single page because there's 9 pages and he got tired after the first 5. I'm not sure why he chose not to sign those. But the seal with some attestation, his signature, should be enough.
And
Do we even know who signed it?
Eric Donovan is the clerk magistrate, so he's the head clerk in Brockton District Court. That information is readily accessible.
well, I'm going to come back to readily accessible in a moment, but so the seal meets our case. Does it also meet the discussion? You would say it meets Duramo, whatever it is, because you can infer from the fact that there's a raised seal that he's compared the copy that's being submitted to the original.
Correct.
He wouldn't. It's inferable that you don't put a seal on it until it is actually reflective of the records of the court.
Yes.
And there's no case that says that.
If you look at Babcock, it says that you would need a seal of the court attached to a certificate of authentication, so essentially his signature. The difference between our case and some of the other cases where you have a seal and a stamp is that here, Eric Donovan, who is the head clerk in Brockton District Court, actually signed it. So instead of using a stamp which has a copy of his signature, that stamp also says that it's a true and attested copy. For whatever reason, when the request was sent, the clerk himself decided to sign these rather than have one of his administrators do it and then stamp it with his signature. I don't think there's a difference between those two.
So could the court have just taken judicial notice of the fact of the prior conviction?
I'm sorry, I missed the last part.
Could the judge have just taken judicial notice of the fact of the prior conviction?
No, I think you would need to present evidence, obviously, because it's a trial and the Commonwealth has to prove that he was convicted of that crime. So the way the Commonwealth
And
did
that
that.
evidence could not be judicially noticed? I mean, judicial notice is evidence. If it's proper to judicial notice, and I thought you can judicially notice the records of the other courts of the Commonwealth.
Yeah, yes, that's fair. I thought you meant without the actual documents.
And there was there's some witness who comes in and says that this defendant in front of you is the person who is the same person who I arrested or whatever on that crime, right? Is that?
Which is what happened in this case as well. Now, the other side of the argument is that the defendant has to demonstrate prejudice, which he hasn't done here. So Duramo, what they did there is say, yes, the copy that was admitted in evidence was not attested to because it was a copy of an attested to copy. But there was no prejudice where we looked at the actual authenticated copy and saw no differences in the material respects. And that's exactly what we have here. The defendant doesn't claim that this record is incorrect or that there's some type of error in it, because there is no error in it, because I went to the Brockton District Court again, this time interacted with the administrator at the front.
Are you allowed to do that after, while the appeal is pending? Like, don't we have to deal with record evidence that was before the court?
No, that's fair, but the court can't evaluate whether there's prejudice unless you look at another copy of it, and if both copies, the Commonwealth's position is that both copies are attested to, they're certified, and they're identical.
The one you got says true copy attest on it with Donovan's signature.
Right, because that was given to me by the administrator at the front desk who used the stamp rather than Eric Donovan.
I don't think we can go outside the record, but I do think your point is, it goes to the argument, to what we were discussing earlier with your opponent, which is, if we're in substantial risk world, sort of what is the test for whether there's a substantial risk? And you would say the test is whether there's any indication whatsoever that the evidence that came in was in some way incorrect. And she says, no, the test is what did that evidence bring to the prosecution's case? Follow me?
Yes, but Duramo addresses this point clearly and says that the defendant in this situation has to demonstrate prejudice, which he hasn't done.
Can I ask you, I happen to know a little bit about district court dockets. That is not the actual docket that's presented at trial.
Correct. The way that Brockton District Court does it is they print something off a computer and then stamp it with the seal.
Because the original document is handwritten, God only knows if anyone could read it, by the clerk that's sitting in the courtroom. So I guess I'm missing why, if it was an assistant clerk, it should say a true and accurate copy, whereas because it's the clerk, he doesn't need to write that. That's where I'm not flowing, because it's still a copy, because the actual docket is handwritten. This was something put in a computer and then printed out. It's still a copy. So why doesn't the clerk have to do something like a true and accurate copy? I'm missing that part of your argument.
I would say the difference is one is a stamp and the other one is his actual signature. So this was he didn't have a stamp of his signature. He actually wrote on every single page, which is why his signature is slightly different on each seal. So I think he's putting his name on that seal saying, I vouch for this.
Okay, another interesting case. It's well argued and well briefed, so thank you both. And
Yeah, very well argued, both sides.
Okay, we're going to hear one more case before our customary break at 11. And, it's another mental gymnastics case, 24P 1185, Commonwealth versus De Silva.
May it please the Court, ADHE Chile from Middlesex on behalf of the Commonwealth. Standing alone, Section 10M requires a sentencing range between 2.5 to 10 years. In Rodriguez, however, the SJC held that the lower end of a sentencing range under Section 10M is 1 to 2.5 years, still reflecting that 2.5 mandatory minimum.
Counsel, I went back and looked at the paperwork in Rodriguez, or the briefs. You're asking us to do exactly what you asked the SJC to do in Rodriguez, and they said no.
No, Your Honor, because in Rodriguez, our point was no sentence can go below 2.5 years. What we're asking this court to do is the sentence between 1 to 2.5 years is the lowest range this court or the SJC can provide without making any provision under Section 10M superfluous. And that's what the plea judge did in this case. When she sentenced the defendant to 1 year and a day, that makes a provision under Section 10M, which is the 2.5 years, superfluous.
Again, these folks know a lot more about this than I do. If you sentence somebody to 1 to 2.5 years, that means they've been sentenced to 2.5 years unless it's later lowered?
Excuse me, Your Honor?
What does it mean to sentence someone to 1 to 2.5 years?
That means the defendant has to serve between 1 to 2.5 years.
I got that part, but, you know, when he hits 1 year, he's now within the range. My understanding of what this is he's been sentenced to 2.5 years unless he gets someone to lower it at some point. Is that accurate or not? I mean, how do they know at the jail after 1 year and 2 days what has happened to his sentence?
So state prison requires sentencing range. You cannot sentence someone to 2.5 years. So in this case, or in general state prison sentence, once you hit the lower end, the defendant is entitled to parole. And that's the whole reason of a sentencing range.
But we're just talking about parole. That's what I thought.
Yes, Your Honor.
So when you sentence to 1 to 2.5 years, you're in for 2.5 years unless you get paroled.
Correct, Your Honor.
Okay.
And what the plea judge did wrong here is when she sentenced someone below without reflecting that mandatory minimum of 2.5 years, that makes a provision under Section 10M, which is a 2.5 years, superfluous.
Didn't the SJC in Rodriguez do just that?
No, the SJC in Rodriguez said, answer the question is 1 to 2.5 years without making any provision under Section 10M superfluous. The SJC did consider that 2.5 years. Otherwise, the legislature could have said the sentence is 1 to 10 years without making that
Well, what
sentence.
they said is the sentence is from 1 to 2.5 to 10 years.
No.
I meant to further answer Justice Englander's question, there's every state prison sentence, except for a few that are prescribed by law, you have to have a minimum and a maximum. And Rodriguez was about what are the minimums. It didn't have anything to do with what the maximum was. And in Mr. DeMayo's language, you're asking for a minimum maximum.
I agree with my friend on the other side, and that is what the Commonwealth was asking for.
Is there any such creature in law?
No, and that's because Section 10 is a specific creature that's being disturbed by Rodriguez. Understand this court has no authority to change Rodriguez. However, there is a way to balance and harmonize between Section 10M, the 3 provision, sentencing provision, and
I don't understand the concept, so I'm ignorant. I apologize, but I don't understand the concept of a minimum maximum. Well, you're asking for 1 to 2.5 years. That's the sentence that needs to be imposed. Anything less than that is below the statutory minimum, right?
That's correct. Unfortunately, Rodriguez allows a judge to go below 1 year for that range. That's why Rodriguez said the lower end of sentencing range is 1 to 2.5 years. The Commonwealth's position is that has to be the minimum. You cannot go lower than that. If you don't provide a sentence where the maximum is 2.5 years, that makes a provision under Section 10M superfluous. And this court, neither this court nor the SJC should be doing that. This is different from Lightfoot, where the SJC considers Section 7 deriving support or prostitute, where the court in that case held it's between 2 and 5 years. The difference between this case and that case is that the SJC did not make any provision under Section 7 superfluous. So if this court upheld the lower court's sentencing 1 to 1 year a day, this court would ignore a sentence the legislature created in Section 10M, and this court should not do that. There is a way to balance both Section 10M and Rodriguez. That way is the lowest a judge can provide is 1 to 2.5 years.
Can I ask you, you sent a perfectly proper 16L letter. You gave us some authorities that were relevant to your brief, and you did not argue, which was great. I appreciate that. However, what was the significance of those statutes? You say they're relevant to footnote 3. I don't understand.
Yes, Your Honor. So in footnote 3, the Commonwealth pointed out, in Rodriguez, the court says Section 10M is a specific creature. It's actually not. Section 10M has the similar idea where the reduction provision goes below the minimum sentence. And the 16L letter points out it's not just 10A and 10M. The list of statutes provide the same structure. If you look at, for example, OUS 7 to 9th, where OUS 7 provides 3.5 to 80 years state prison, it cannot be reduced less than 3 years. So this provision, or that interpretation the lower court is providing, will impact more than just 10M. It will impact 10A.
Any of those examples that you've provided to us been construed?
No, Your Honor. This will be the first time. If there are no further questions, the Commonwealth.
I just want to, so I looked at the very last one that you said. It was I think it was deriving income from prostitution or something like that. And
Yes.
it said, shall be sentenced to 5 years. And then it said, in no case less than 2. So you're saying that one, that one has to be 2 to 5. Okay.
And I apologize for my answer to Justice Engler earlier. There's actually one case construing one of the statutes, which is Section 7. That's from Lightfoot in 1984 from the SJC that Rodriguez cited in footnote 3 or 4. The court in that case.
Section 7 of what chapter?
It's 272.
Okay, that's the one we're talking about, yeah.
Right. So in Lightfoot, the court was balanced between the sentence of a period of 5 years and should not be reduced to less than 2 years. The SJC held that the sentencing range proper under Section 7 is 2 to 5 years, without making any provision superfluous. And that's what the Commonwealth asked this court to do here, to take every word in Section 10M into its account. And the way to do that is a minimum maximum sentence.
So I just want to make sure I understand. So if the judge had sentenced from 1 to 2.5 years, that would have been okay?
Yes, Your Honor.
And similarly, obviously, if the judge had sentenced from 2.5 to 10, that's a proper sentence?
Yes, Your Honor.
Okay.
So my friend on the other side really captured it well. It is a minimum maximum sentence that Section 10 may require. And that logic will extend to other statutes the Commonwealth lists in 16L letter. For example, OUS 7 is 3.5 to 8 years state prison, should not be reduced to 3 years. So the minimum the judge must give in that case will be 3 years to 3.5 years. In that way, this court will harmonize Rodriguez and all the other statutes that have similar sentencing structure.
And you said there was a 1994 case that construed 272, Section 7. It's not in your brief, right? What was the site?
It's a 1984 case of Commonwealth v. Lightfoot. It's 391 Mess 718.
I'm sorry, I interrupted you. Give me the number again.
391 Mess 718. It's a 1984 case construing Section 7 of Chapter 272. If there are no further questions, the Commonwealth urges this court to correct the lower court's error and a published opinion provide binding guidance to lower courts. Thank you.
Everybody has a question of law today.
Good morning, Christopher DeMeo for Mr. De Silva. So I see this case as it's obviously a statutory interpretation case. The question is, what do you do when you have a statute that apparently has two minimum sentences? And our position is, using the rule of lenity, you go with the lower one, and you.
I'm not quite sure I understand why you say that's what the statute says. What the statute says is that a person's sentence can't be reduced to less than 1 year, which is a parole eligibility phrase that's used.
Correct.
So,
Well, it's a little more than that. It is parole. It certainly involves, it's various things that involve the executive. I don't think it's just parole. I think there's good time, and I think they get credits for classes. But that language, if you read it, also talks about suspension. And the executive doesn't suspend sentences. Judges do that. So it's kind of a mess. I think that was the point the SJC had in Rodriguez when the Commonwealth made this argument. Well, the first part is about judges, the 2.5 years. The third part is about the executive. Well, it kind of is and it kind of isn't. But so the question is, when you have these kind of cases with, you know, two minimum sentences or a minimum sentence and a mandatory minimum, what do you do? Our position is you go with the lower one under the rule of lenity. I think the government's arguing, well, you take, if you do that, you'd be kind of wasting, it would be superfluous, the higher of the two minimums. So you take that higher of the two minimums and you make that the least maximum. I mean, it's a coherent argument. It's just kind of a weird argument, I would submit. And I don't know. I don't know of any cases that say that. And I was rereading.
But it's weird. I mean, the Commonwealth responds to your point by saying it's weird because of Rodriguez. They're saying Rodriguez misread the statute. And now we're stuck with this animal that 2.5 is not required.
Correct.
But what Rodriguez actually says is the lower end is 1 to 2.5 years. That's what it says. So, I mean, why shouldn't we take that at its word? You can't go below that.
Because they didn't say it was the minimum. I mean, if they had wanted to say, and they didn't need to say it because it wasn't really an issue, that, and in no event shall the maximum sentence be less than 2.5 years, they would have said it just like I said it. But yes,
No,
1 to 2.5 years is at the lower end, 2 to 4 years is at the lower end, 2 to 3 years, I mean, it goes up to 10 years. So I don't know you can put that much in that language. The Rossetti case, I just want to bring to the court's attention, which both sides cite, I think. It came out in 2022 after Rodriguez.
It doesn't say at the lower end. It says the lower end of the sentencing range is from 1 to 2.5 years with at least 1 year to serve in state prison. I guess and they say it twice.
They say it twice, yes. Yeah. The Rossetti case.
Why should, I don't want to get you in an infinite loop here. I think I already heard.
I mean, if this panel thinks that clearly implies, and in no event shall the maximum sentence be less than 2.5 years, then we lose.
Well, the difficulty with it, and I mean, we understand your argument, or I do. I mean, I think these guys too. The difficulty with it is that if you're right, if Judge Hand is right, then 2.5 years, the language in that first sentence has become irrelevant, hasn't it?
It has, but as I think I point out in the brief, 10M absolutely has irrelevant language. There's no question. It's just a crazy, it has stuff about you can't suspend.
There's lots of irrelevancies, so why should we worry about this one?
Right. I mean, you want to make it as rational as you can, but the idea that the SJC never said we were going to construe this so that there's no superfluous language. You can't suspend a state prison sentence. There's just all kinds of stuff in there that doesn't make a whole lot of sense. So can you read the lower end of the sentencing range as you're suggesting? Yes, you could. I don't read it that way. I think it's just sort of rhetorical language that, well, we've got a year and we've got 2.5, and that's what the judge did in this case.
Lower end, like by statute, you've got to give a lower end and an upper end. So, right? I mean, lower end means when you give a 2 to 3 or a 5 to 10 or whatever, lower is referring to that first number, right? That's the lower end, right?
I'm not sure I understand.
When the SJC is referring to the lower end of the sentence, they're meaning when you give a indeterminate sentence between a certain year and a certain year, the lower end is the first thing, right?
The lower end is the first part of the, yes. Yeah. Normally there's only one.
That's right.
There's only one date on each side, so it would be 1 year to 10 years. But here they're saying there's 2 dates on the upside, there's a 2.5.
Usually there's only one choice for the lower end.
Right.
Right, but the SJC said you have a whole range of choices for the lower end.
That's how I took it, right? And certainly Judge Ham could have said 2.5 years, or she could have said a year and a half, or whatever. But anyway, the language from Rossetti that I was going to read, it says on page 602, the presence or absence of minimum term or mandatory minimum sentence language is irrelevant to the analysis surrounding whether the statute creates a maximum term. So I don't want to read too much into that, but that seems to be somewhat intentional.
What's the pin site of that?
That's the Rossetti case.
Pin site.
602.
Thank you.
602. A couple other points I want to just make quickly. The 16L letter, I thought that was interesting because when I got this case, I thought it was sort of a one-off case about 10M. It's this weird statute, and it was just about that. But it seems to me what the Commonwealth is actually asking this court to do is to create sort of a new canon of construction, which will apply to 5 or 10 different statutes, that whenever you have these cases with which appear to have 2 minimum sentences, you're going to...
cannot be reduced to.
Yeah, exactly. You'll take the lower one, make that the actual minimum, and take the upper one and make that the least possible maximum. So
If we were following Rodriguez, I suppose, and
I would
Rodriguez
just
wasn't
submit,
one off.
this is a common law court, so if you want to do that, you can. But it seems to me creating a kind of novel canon of construction that's wide-ranging and, to my mind, dubious is not, maybe the SJC can do that if they think it's a good idea, would be my suggestion there.
Does it matter, are all of those other statutes, they have mandatory minimum language, or do they just have minimum language? Sounded like they didn't, the one that was read was not a mandatory minimum.
To be honest, I didn't read them all, but I read the one about the house of prostitution, and it was the same thing. It said 5 years to serve, but in no event shall the sentence be reduced or...
It said the sentence shall be 5 years, like no range, just it shall be 5 years.
Yeah. And,
oh, by the way, it can't be less than 2.
Yeah, less than 2, exactly. It shall not, but similar in structure, so I agree with the Commonwealth there. So the argument is really not just about, it's not a one-off about this weird 10M language, but if this panel were to adopt the Commonwealth's argument, it would be sort of a new canon of construction, it seems to me. And the last point I guess I would just make that I didn't hit in the brief is that this sort of goes to a judge's discretion where they have typically maximum discretion sentencing. Now, clearly if the legislature had said you got to do this in clear language, then that's the end of the story. But where it's ambiguous here, I would submit that the court should be a little bit hesitant to curb the judge's sentencing discretion here. Judge Ham, I think, when you read this, she was trying to deal with a whole slew of 26910 charges, and it's tough because some of them can be in the state prison or house of correction. Some are only in the house of correction. Some are only in the state prison. I think she was trying to sort of separate off this 10M, which was in the state prison, by resolving it and saying it was deemed served, and that's how this all came up. So that's just a judge trying to deal with a difficult situation. So there is a cost to what the Commonwealth is asking for. It will take away their ability to have that kind of discretion to solve these kind of problems. Those are the points I wanted to make.
Okay. The case is submitted.
Thank you.
Again, thank you both. Another conundrum for us. So we are going to take about a 15-minute break. We should be back here at about 10 after 11 for the for that number 5 case, which is the DCF case, and then we'll hear the Hilton case after that. Okay, we are back on the record with 24P1161, Department of Children and Families versus Father. I remind the parties that this is an impounded case, so we will not refer to anybody by name. We'll try and describe them as father, mother, and in this case, daughter. Attorney Barreto.
Good morning, Your Honor. Kevin Brett on behalf of the appellant father. Father wants visits with the child, but however, there was a 209A order from the district court which prevented father from having contact with the child. So due process right to counsel includes the right to be heard in a meaningful manner and to rebut the state's allegations. And in this case, as indicated, as there was the 209A order in the district court, the right to counsel is not meaningful if the child counsel doesn't go to the district court in order to attempt to modify that court order in order for father to have the opportunity to have visits with the child.
So can a lawyer that's appointed in the juvenile court for the father file an appearance in the district court for the father?
I don't see anything that would prohibit an attorney that is assigned to represent father in the juvenile court to also file an appearance in the district court.
Have you checked the CPCS guidelines? Because the lawyer was appointed through CPCS as a court-appointed lawyer. You sure the guidelines don't suggest that a lawyer can't do that?
I think that there are avenues that could be reflected that in the guidelines. Also, there's reference to collateral representation. So if there's an issue that's integral to the matter that the attorney is assigned to, that they could obtain permission from CPCS to handle a matter that's not solely what they were assigned to, but is integral to that matter as well.
Just get a few facts out so that, so lawyers appointed in 2021, correct?
The end of December in 2021, correct.
So December of 2021. And at that point, the father is under a lifetime restraining order, so he can't see the child at that point, right?
That's correct.
And also has not established paternity.
At that point, he had not established parentage of that child.
So he had no right whatsoever to visit with the child until he establishes he's the parent, correct?
That issue also could be an issue related to the ineffective assistive counsel because the filing of the parentage action occurred 7 months later, I believe in July of 2022. And there was no dispute related to father's parentage of the child. The child has father's last name. There's a twin sibling that shares father's first and last name.
Do you think that the father's counsel, appointed in December of 2021, could have gone into the district court and got the lifetime ban on visitation with a child? Because that's what you're positing, right? That it would have just changed visitation with the child, that he could have done that without first establishing parentage?
I believe that could have been done because it's the district court order that prevents father from having contact with the child. So if a child counsel returned to the district court and requested a modification, that would be something that the district court would be able to hear the modification because there would have been a change of circumstances at that point. At that point, child would have been in DCF custody. And so the information could have presented to the district court at that time that...
Would the judge modify the order without under those circumstances, without hearing from DCF? So, I mean, there's a series of hypotheticals here that we're working our way through in order to get to an ineffective assistance of counsel argument, right? And it seems to me that if I'm a district court judge, which I haven't been, but some people on the bench have, I would ask the question where is the child now? Because the request is to alter the lifetime ban so that he can have contact with the child, find out that it's in DCF's custody and say, well, have you notified DCF that you're looking for this change? At which point DCF comes in and says he hasn't established he's a parent.
And I can put a fly into the ointment because I was a district court judge, and a district court judge can't issue visitation orders on a restraining order. So the only thing that district court judge could have done, which is my follow-up question, is he would have, or she, would have had to terminate the restraining order as to the child. And you need, on an ineffective assistance, to tell me how likely that would have been to succeed, because that's the second prong of an ineffective assistance claim.
So there could have been, right, so it would be the modification of the 209A order to remove the child from that list, and indicating, the question is, where is the child, if that's the question that the judge could have had, that the child would be in DCF custody, that contact with the child, that father would have with the child would be by video, be supervised by DCF.
Can't do that. District court judge can't do that, counsel.
Okay.
The only thing the district court judge could do would be to terminate the order as to the child, meaning that there was no basis for a restraining order against the child. So tell me how the lawyer, if he had done that, would have been successful with all the issues that were in there at that time.
So even if the district court judge didn't have the power to do that, he would, the judge would be able to hear to that information how contact with the child would take place, and that there would be no harm to the child because those visits would have been done
Counsel,
by...
you're not hearing me. I'm sorry. I was a district court judge for a long time. A judge cannot do that, cannot have anything to do with visitation, can't do telephone calls, can't do anything. The judge would have one of two options, either to leave the restraining order as it is and say, go to the probate and family court regarding visitation, or give me evidence as to why I should terminate the order as to the child. And from your claim where you're saying the lawyer was ineffective for not going to the district court, you have to first show that he would have been successful in terminating the order. And I'm asking you, based on the facts that you know, how likely would it have been for a judge to terminate the order as to that child?
Right. So I understand that the judge in the district court doesn't have the power to have the visitation, but the judge would still be able to hear how visitations would occur and take that information into consideration in modifying the order to remove the child as part of that order. Again, that the
Would
child...
a probate court judge have had the power to amend the 209A issued by the district court in order to provide for visitation? Probably would have, right? No? Yeah, probably would have.
I believe I guess I'm uncertain to that issue because the issue was heard in the district court, so I'm not uncertain of whether or not the probate and family court could also have...
There is a statute that addresses this question.
And it's right on the order itself that says if you want visitation, go to the probate and family court. It's right on the order itself.
Do we have a copy of the 209A in the record?
That is, I believe that that order is part of the record.
Can you tell me where? No, you can't, probably not, without taking a long time. But you think it's in there?
Yes, Judge.
Okay. And one more thing, wasn't the father convicted 3 times of violating that order?
There are convictions related to violation of the court order, yes, Judge.
So again, how likely would he be able to get it taken away when he'd violated it 3 times?
So again, the likelihood would be, because there was, the district court would be able to hear that there's a change of circumstances, particularly that the child is currently in DCF custody, and that there would be visits that could be arranged, even though the judge wouldn't be able to order those visits, that visits could be arranged that would be online, that would be supervised by DCF, and that there would be no harm to the child.
When did the child go into DCF custody?
Believe that there was a few times where the child...
The last time, the time that led to the C&P that went to trial.
Have the,
2021, or was it earlier than that?
I believe it was in December of 2021.
December 2021.
That's when the CMP was filed.
So the child was still with the mother, at least off and on, until December of 2021?
And then the child was returned to mother's care, I believe, in July
2022
of
again, right?
2022.
Yeah, okay. Okay.
I mean, so even if we agree with you on that, I mean, the part of the judge's ruling in the denial of the motion for new trial was, even if I agree with you on that, there's still 8 years of the child's life where father didn't make any effort to try and to get the restraining order altered or to try and visit her. And this is a child that has substantial needs, right?
So what the record reflects is that father didn't know how to go about that process, and that's shown in when father first takes action to try to amend the court order after there was inaction by the trial counsel. Father just writes a letter to the district court asking for modification of the court order, and so the district court takes no action on that because it doesn't follow the procedures.
But that's like after 10. That's not in the first 8 years. That's after 10 years.
It just shows that father didn't know or didn't know the process to get that matter handled. And then when he did have trial counsel, and again indicates that countless or every communication he has with trial counsel, requesting trial counsel to take that action, that trial counsel didn't take the action to modify the court order to protect father's due process rights to have visits with the child. And this is something that different outcome that could have occurred had those visits take place is essentially father was powerless, that throughout this case, the 2 years of this case, the restraining order continues to be in place. Father didn't have visits with the child, so then at trial, father was powerless other than have the outcome that there was no evidence of any pattern of visits with father had with the child. So a different outcome had that there been their modification of the order, had it been successful, that there could have been established a pattern of visits with the child, that father could establish himself as a visitation resource to the child, could have, again, things how it would be in the best interest of the child, have a meaningful relationship with the birth family for the child. Again, child is in a foster placement. There isn't a pre-adoptive home, so as to any uncertainty whether or not an adoption will occur, it would just, as for the child, as the child ages out of the foster care system, that there could have been the best interest of the child of father being a resource for the child.
Time of trial. Trial was when, 2023?
Yes, Judge.
Time of trial, was the father under a restraining order with respect to his sister?
There had been a restraining order related to the sister.
Asking for evidence in the record. So there had been restraining orders. Does the restraining order still exist? Is that in the record?
Because
some of those were only like a couple weeks long.
Right. I don't believe the restraining order related to the sister was still in effect at the time of trial.
Father, is it in the record whether the father had had visitation with his son?
That, I don't believe there's any evidence of that in the record, Judge. And then there's also, again, part of the trial counsel's failure to file for the modification of the order was, again, father went to self-help, tried to do it himself, but then trial counsel also failed in presenting evidence of father's attempts to modify the order, and that led to the trial judge lead to the conclusion that father had never made attempts to modify the order, which was erroneous given that father had made those attempts to modify the order. If there are no further questions, I'll rest on the brief.
Seeing none, thank you.
Thank you.
We'll hear from, I think, the department first, and you're dividing your time 10 and 5?
Correct, Your Honor.
Okay.
Good morning. Matthew Price on behalf of the Department of Children and Families. The department is asking this court to affirm the decision of the lower court that terminated father's parental rights. Excuse me. There was no due process violation in this case. Father had notice, he had an opportunity to be heard by the court, and he had the opportunity to be heard by the court based on the work that his attorney did in filing the petition action, the paternity action. The crux of father's argument boils down to dissatisfaction with how the trial court weighed the evidence, and that alone is not enough to remand the
The
case.
court made a mistake in saying that the father had never tried to change. The court made a mistake, right? There's an error in the findings of the judge to the extent that the judge says the father never tried to amend the restraining order. That's wrong. Factually incorrect. Let me start there.
Well, I respectfully don't agree, Your Honor. I think that the extent that what father did over a period of 8 years of inaction was he managed to get a hearing scheduled in an attempt to modify the restraining order. That he did. But what he didn't do was the key point of appearing for the hearing. And I think that reading into the trial court's decision on that, it was an error. He recognized what the father did, but making the hearing amounted to nothing when he didn't show up.
Oh, did the court recognize what the father did? I thought that evidence actually was never presented to the court. So that's why I misspoke off the top. I'm not sure the judge made a mistake. I thought that the argument here is that it was ineffective assistance of counsel because the evidence that the father had tried to schedule hearings wasn't presented to the judge. Do I have the facts right now?
I think you do. The trial court's decision as far as that was that he did not appear for the hearing.
That was later. On the motion for new trial, that's what the judge said. I think on the actual findings, I don't think it was presented until the motion for new trial. But anyway, I can read the materials.
Even if there was, the hearing was held, if there was modification to the restraining order, even if there were visits, and even if visits went well, even accomplishing that is not enough for the judge to necessarily, that's not dispositive of his fitness. There were plenty of other reasons that the trial court gave that established father's unfitness, which was long periods of incarceration between 5 and 10 years, repeated criminal behavior that I think amounted to 56 convictions, a father who took no action to establish paternity or trying to modify the restraining order previously, not having anything to do with the child's life or an attempt to have anything to do with the child's life, and not understanding the significant degree of the child's needs. All of that, even if visits went well and there was no issue there, was enough to
Do you know the answer to the question whether the record shows that he has any visitation with his son?
I don't know that he has visitation with his son, but my understanding from the record is that he doesn't have contact with his son. He hasn't been a caretaker for any of his children, is
what the record shows.
That's my understanding, yeah.
So one of his arguments is in terms of reasonable efforts is that the department didn't make much of an effort to reach him in prison, provide him with action plans, or if so, the attempts were just superficial. Is that correct as a matter of the record?
I'm sorry, I missed the last part of the question.
Or at most, the department's efforts to get in touch with the father were superficial. Does the record reflect that there was more than superficial attempts to try and help him reconcile with the daughter?
Yes, there was. The department has to make reasonable efforts, and reasonable efforts are based on the context. In this case, father hadn't had any contact with the child for...
I'm asking what the department did to try to help facilitate it.
They maintained contact with him through, they provided service plans. They contacted his case manager and parole officer when he was incarcerated. They made efforts to contact him when he wasn't incarcerated. They, the social worker asked him to get in touch with them because of the difficulty that they had in reaching him, and provided, I think pretty consistently, the service plans to try to do towards reunification. What reunification, I don't really know, because they were doing that against the backdrop of a lifetime restraining order and the fact that the father hadn't established paternity. So I think that in that context, what they did was reasonable and sufficient, and it wasn't error on the judge's part to find that reasonable efforts were made. He actually thought that that was frivolous, I think is the word he uses in his findings. So as far as that goes, I think that was father hasn't established either of the elements to establish ineffective assistance of counsel, in addition to really establishing his standing in the case. The attorney cross-examined witnesses, filed motions, made objections, gave a closing argument, and preserved his appellate rights. And there's no affidavit from trial counsel to know what was his strategy or why he used or didn't use certain tactics that would explain the issue around the modification. I could only speculate, but he may have realized that he wouldn't have had much success on modifying the restraining order before the paternity.
But I think one of the arguments you make is that it would have actually contradicted the father's testimony that when he found out that he actually tried in 2023, you're saying, and father said it was 2021. But when father said 2021, was that like a definite thing, or is this kind of a guess? People don't always remember.
My understanding was that was the testimony.
Yeah.
Was
it more like, I think it was 2021, or definitely it was 2021?
My interpretation of how the judge took that was that he said he did it in 2021, but the evidence of the records certainly contradicted that. And
By what, 6 months?
sorry.
By what, 6 months? When did he try? 2022 during the summer, right?
Yeah.
So he was off by 6 months.
Yeah. I think that in addition to the other things, having not followed through on the hearing or done anything for the previous child's 8 or 10 years of life, was significant in his decision-making. The prejudice prong isn't satisfied either. The judge addressed the matter of the restraining order in conclusion 14, and I think settled that even if that was not an issue, there still would have been sufficient evidence for the unfitness. And otherwise, the other evidence of father's history was overwhelming, even if he had been prejudiced, which I wouldn't concede. If there's no questions, the department will rest on its brief.
Okay, thank you.
Thank you.
Good morning, Your Honors. My name is Sherry Avalon Niles. I represent the child who's currently in DCF's care and remains in the same foster care placement as she has been at the time of removal. We respectfully ask the court to affirm the lower court's findings that the father's rights be terminated because father has been inaccessible, unstable, incessantly incarcerated, and all of it combined leads to his undeniable unfitness to parent this child. Father's counsel would have us believe that this case is about the ineffective assistance of counsel and systemic failures. But really, this case is all about Father's poor choices that he's made throughout this child's entire life. Father, fundamentally, we understand that these cases are difficult, terminating a parent's rights. However, child welfare cases are not about the welfare of the parents or prosperity. It's all about the well-being of the child. Father has been, and will continue to be unfit, which necessitates that this child be freed for adoption. The basis of this is the clear and convincing evidence, as set forth in Adoption Valona, that Father, by clear and convincing evidence, Father has been found unfit, and his rights should be terminated as it is the child's best interests.
Can I ask you, like, the child has significant special needs, right?
Significant special needs, which renders this father in particular incapable of supporting this child. This child has ASD, she's autistic, she has ADHD, she has microcephaly, she has aggressive behaviors.
You mentioned, it'd be helpful for her to be free for adoption, but is there really much likelihood of adoption?
There is,
So, and which leads me to the question, so wouldn't it be better to have some parent in her life, even if maybe not custodial, but in her life?
Justice Massing, this is something that I have deliberated for quite a long time. This child has no one, absolutely no one. Her brother went up for adoption. Her twin brother and her sister are in placement under guardianship with the aunt. She has no relationship with the mother. The mother stipulated. Father is all that she has left. But the problem with Father is that he has not shown up for her. I agree that it would be best if she has someone. She's 11 and a half years old. She has severe and significant mental health needs, which makes it more difficult for her to be adopted. The issue is, Father has been unstable, he has been inconsistent, he has been very indifferent towards her. So the question is whether it will be in her best interest for him to be in her life at all. He has not shown up, and he has not shown a consistent pattern of being there for any of his children, let alone this child.
Was there questioning at the trial about his knowledge of her special needs?
Absolutely, yes. He only learned about her special needs in October of 2023 through the social worker 2 months before the actual trial. And his response is, she needs a tutor. That was his best response to handle her. He also testified in his testimony that he will make every effort to address her special needs, but the lower court did not give any credibility to that, seeing that he has had no stability and consistency in anything that he has done. I would like to address some of the questions that you asked before, if I may.
You've got 50 seconds.
Oh, gosh, yes. There was evidence, the record did not show any attempts that Father attempted to modify the restraining order. That is correct. Also, there is in the record, in the findings.
Until the motion for new trial.
I'm sorry?
Until the motion for new trial.
I am not certain
The motion
about
for
that.
new trial, then he put in that evidence and the judge addressed it.
But yes, he addressed it in the motion for new trial, saying that it would not have made a difference because Father was supremely unfit. Also, the record does show that there have been, back in 2015, and with the first set of orders, that the social worker had attempted to put twin and Father together in terms of some sort of action plan to have them have contact, whether it be visits or medical, something, but the record does show it in the findings. And you asked my colleague.
That's all it shows. There were some efforts, no indication that it actually happened.
No, I didn't see anything to that effect, but there was something in his action plan that indicated that he should follow up on child's needs, and that was all that was put in the 2015 action plan.
Okay, well, that is your time, and we appreciate the advocacy of all of you on behalf of your clients. So The case is submitted.
Thank you, Your Honors.
All right, our last case that we're hearing today is 23P1471, Posner v. Hilton. And Mr. and Ms. Hilton, brother and sister, right? Yes. And I understand you're going to take the first 12 minutes and give three to your brother to finish up?
The idea is that I would mostly be arguing, and we wanted my brother available to answer questions, because we each have different
Because
strengths.
have you seen we interrupt with questions?
I know, so I'll defer to him when I feel that my expertise is not necessarily the best aligned to answer it.
So make some notes on what you have to do to bat cleanup here.
I'll do my
Okay.
best to answer them. All right. Members of the panel, may it please the court. I am Anna Hilton. This is my brother James Hilton. We are pro se unified appellant defendants in this case. At the heart of this appeal is that the lower court erred in granting summary judgment despite the existence of unresolved issues of material fact, and prejudiced us by not allowing for a complete and full record. This would warrant, at a minimum, remand for further proceedings. But in light of subsequent events and the time that has elapsed, this is not possible to complete discovery. And thus, the only just outcome of this appeal is reversal of summary judgment. Berry v. Commerce, 2021. Summary judgment is only appropriate where there is no material issues of fact in dispute. Federal National Mortgage Association v. Hendricks, 2012. Evidence for summary judgment should be reviewed in the light most favorable to the non-moving party. This is the precedent. These conditions were not met in this circumstance. And while there are multiple examples of this, I'll focus my time on discussing the most glaring example, which relates to the evidence provided by Google Maps, as it was misunderstood by the lower court. Then I will review issues that could not be appropriately adjudicated secondary to the plaintiff's obstruction of discovery in this case, obstruction of laws of succession, and even her testifying to a different violation she committed in order to avoid following the rule of law pertaining to this case. So I would start with Record Appendix 1, page 40. That's the Google Maps screenshot that we submitted in evidence. And this was what was misinterpreted both by the appellee and the judge by the lower court. And appropriate.
May I ask you? I do want to ask you a question. But
Yeah.
How did you? So this is that you received. You somehow got that from a history, right?
I can describe. That's actually what I'm going into right now.
Great.
Because I realize it's what's most misunderstood, and that's why I'm focusing on it right now. So an appropriate interpretation, I believe, would have precluded summary judgment, as it is an issue of material fact that warrant further.
Well, so I understand you're not a lawyer, but the issue of material fact means, in this context, at least to this judge, that this evidence is sufficient to allow a finder of fact reasonably to find.
Yeah.
Okay?
And so,
reasonably to find that a fraud occurred with respect to, I think it's the 2019 event having to do with the beneficiary on the life insurance, right? So we're talking about I'm looking at this January 17th, 2019 document. So it may be that there's a misunderstanding as to what this shows.
Misinterpretation.
And yet the misunderstanding is not sufficient to get you to the point that you've proved that a fraud occurred.
I believe it is.
Because there are multiple pieces to that, including, even if you assume, I think what you're going to tell us is this shows where your father was at a particular time on a particular day, right?
May I explain how I believe it shows that he was there, he was driving, and it precludes him from being the one to make the change? Would you like to hear how that is the case? I know it's in our brief, but I feel like it was what was the hardest to capture on paper. Is that okay if I proceed?
Was it in your opposition to summary judgment as well?
I don't think it was detailed as much as it was in our brief, but it has been throughout the case present.
Because we, as an appellate court, we review for error.
Yes.
You don't get to redo it here.
No,
We need to know that the argument was made below in a way that was sufficient to establish what you're about to tell us. So I'm giving, and I went and I looked at your opposition, and unfortunately, the entire opposition was not in the appendix, just the factual component of the opposition, not the argument. However, I do think, at least, I would like to hear you sort of walk us through this.
Okay, may I continue? Okay, thank you. So Judge Monks on the lower court had wanted a time-by-time, minute-by-minute log of exactly where my father was to demonstrate that he was driving. And I thought explaining exactly how the app worked, how we access this data would be the best way to show how that was a misinterpretation, that is the only way to show that he was driving to work.
So how did you, back to my question, how did you get this screenshot? What is it?
So what happens is that, I mean, this can be reproducible by anybody who uses Google Maps. It's ubiquitous. 2011, Google Maps made it so that you could access or Google made it so you could access any data they collect on you. It was difficult to access, though. 2018, they upgraded their privacy policy, and now you have an My Activity tab that you can look at. Anybody, you could look at your own and see exactly how you've interacted with apps. And so these app interactions, the logs, are only recorded when you interact with the app. So let's say when you put in your request for directions. And the most confusing aspect of that screenshot is that it says current location, and it's my dad's work address. However, current location, this is a metadata. This is like a library storage way to log data in a concise way. Current location means the current location that is needed, that needs to be input, because the Google Maps didn't know this data before you opened the app and interacted with it. And so it is the location that you are using maps to locate. It already knew our dad's actual physical location, which was near his house, not at his house. So either
How do you know that?
because of the map that is present on that screenshot, that is an approximate GPS location. That's why there's no exact address.
How do we know it's an approximate GPS location? What is it? I mean, that's a pretty broad area.
So that is just on the street from 225 Pleasant Street, Millis, Massachusetts. It's in Millis. You can see it says Acorn Street, it says Village Street, Route 115, like it very much specifies a location. The reason it's not an exact address, as I said, is that it's using GPS.
Is the location within the box?
Yes.
Okay, how do we know that?
That is what that's what I believe the maps, that's why it shows that. What else would it be showing? Like conversely, why would it put a box around an area that
Was that
is
explained
unrelated?
in the opposition?
Not to that detail, because we had separate counsel at the time that was unable to, or did not
Okay.
capable of describing that. And if you have more questions on that regard, my brother may be able to answer in his
Can we
time.
go back to Judge Massing's question?
Yeah.
How did you get this?
So,
This is from
absolutely.
your father's mobile phone, from your father's laptop?
No.
What is it?
Google account. So Google logs everything that you interact with it for. Again, not all the data, again, not
You
minute by minute.
remotely access your father's...
Because Miss Hilliard wrote
I'm
down.
sorry.
Oh, sorry.
I have to
Sorry.
ask the question so that I know what I'm asking.
Yeah.
Someone accessed your father's Google account remotely? Is that what happened here?
So everything on Google that we had was remote. Miss Hilliard wrote down his essentially master password for his password vaults, you know what remembers passwords, after his death. Even though she said she knew no passwords, we used the password that she wrote down to then log into his
Did you
account.
folks access, or did someone access remotely your father's Google account to look at what your father's Google account showed
Yes.
for his interaction with Google on January 17th, 2019?
Yes.
That's what happened?
Yes.
So that's what we're looking at. So then you can get access to the Google account and you can take a screenshot?
Yes. I don't know how else you would submit that to evidence.
But no, I don't understand. There's a whole lot of things I don't understand, okay?
And I'm trying to clarify so that you understand why we.
Yeah, but I have to ask the questions, otherwise what you're telling me may not help, okay? And
Absolutely.
here's what I don't understand. Why is it, so presumably your father's location changed during the course of this trip.
Yes.
Why is it that Google isolates this particular map?
Because it's metadata, so it's just a log of the interaction with the app, not all the data that the app utilizes to function. So this is when he interacted with the app. This is
I
what he
see.
was requesting.
This is where he was when he,
Interacted with the app.
got it.
Whereas, of course, Google is using your GPS to continue giving you directions, but it doesn't log that for future access, necessarily.
Got it.
On to another subject. We don't
Yeah.
have the time.
I know, I have another really important point, if I have time. Thank you.
You have another?
I do, if
Go
that's
ahead.
possible,
I'd
but I
like
can
to
wait
hear-
for your question.
No, let's hear what you
All
want to say.
right, so I did want to ask, and I had a much bigger spiel, but to honor our time, I also asked by what Massachusetts rule or statute did Ms. Hilliard have to possess items that she admits did not belong to her, this is in her deposition, were not used by her, and she had no expectation of inheriting, as she had no legally recognized relationship with the intestate decedent. The answer is no right and no precedent. She refused to give us essentially our father's items, so computer, hard drive, phones, etc., as part of an estate process, and then also could not, by her own description, search them for relevant evidence. She herself interpreted documents to mean electronic records. Almost everything submitted in this case are electronic records. So why would you exclude those electronic records? Again, the computers were not searched per her. They didn't belong to her, per her.
I think I will be asking.
Yeah, and so why would you?
I want to ask you. So I do want to ask
Yeah.
you then. A couple of things in the brief.
Absolutely.
And maybe it'll be your brother who will have to answer, but on page 21 of the brief, from James's affidavit, he says that your father had a heart attack after a heated argument with Ms. Hilliard.
Yes.
How do you know that?
She's told us while we were all in the ICU for a week while he was unresponsive. She said many things in the ICU that were.
So is that anywhere in the record? Is that just that's just?
No, that's my recollection. I apologize. That is what my brother recalled as a first person experiencing that. What she told him.
And on page 9,
Yeah.
you say that your father had no knowledge and didn't authorize Ms. Hilliard to change the beneficiary.
Yeah.
Again, how do you know that he didn't have any knowledge of it and didn't authorize it?
Well, if he was, for example, if he were driving at the time of a beneficiary change, how would he
couldn't
be
he
the
have
one to enact it?
So-
And there's no policy
You
included
don't
from
really
the.
know what their discussions were. You don't know if he
Well,
told.
she did not either. She reported she did not know that they'd minimally discussed finances over the years.
Well, she
realized.
says that she didn't do it, that he did it, right? I mean, she
Yeah.
made the change. Okay.
I have one more question, yeah.
Yeah,
So
certainly.
a key component of your
They
argument.
have 3 more minutes on the other side. Maybe it should be for the brother?
I think my brother is
That's
okay
fine,
yielding the time to me if that's.
Okay, yeah. Oh, he's yielding to you? So you want to add 3 more minutes?
Do you want to add
Or-
anything?
Actually, you don't have to.
Yeah, so the authenticity of the signatures is that they were, compromised because she knew his master password and access to all his accounts.
Go ahead, Justice Englander, I'm sorry.
So how are we going to do this? We're going to reset for 3?
No, I think we'll just watch
we'll
the clock
go to
go up.
3?
We'll just
Yeah,
watch
we'll
the
watch
clock
it go
go
up.
up.
Thank you.
Okay. A component of your argument about the January 17th, 2019
Yeah.
event is that if he was where this box is at 9:21, he
Yes.
could not have been at work at 9:50.
Yeah.
How far away was work?
So if you use Google Maps at that time, it was approximately 40 minutes away.
So how far, where was work and where, this is in
He
Millis?
lived at 225 Pleasant Street, Millis. This is at Village Street, which is probably, this box is most likely like a mile from his house.
Okay, and where did he work? Marlboro.
In Marlborough,
somewhere.
Massachusetts.
Yeah.
So you would have had to go through, either Bellingham or Milford or
The 109
take
to 495.
Yeah.
That's how we would have gotten them all.
during morning traffic.
Right.
Okay.
There's you refer to in the brief, and it's in the record, there's a piece of paper
Yeah.
where it's in handwriting, it's
Yeah.
got Crunker 1 written on it.
Yeah.
And that's, according to something, that was written down in front of your brother and your father's coworkers?
Yeah, they had
When
come
did-
to the house because he had died suddenly, and they didn't have access to all his his work for Helen of Troy. He did work from home some days. And so they came over seeking anything that might belong to Helen of Troy. My brother was also present. And so they were also asking, do you know what his passwords might have been so that we can try and access some of his work-related things, because we need to continue his projects. And so that's when she wrote it down for them, not necessarily for us, but my brother was present and took a picture, realizing the importance at that time. Her pattern of behavior had already been very obstructive and very, yeah, that's the password that gained us access to his password vault.
I have a couple more questions on your brief.
Yeah.
On page 13, you list a bunch of Google searches
Yes.
that are about, changing passwords and stuff like that. How do you know those weren't your father's?
I can't say with 100% certainty it's the pattern, but for example, that Marianne Hilliard logged on, well, the Facebook of Marianne Hilliard was logged onto in that time frame of those searches based on the web browsing data. Again, this is all accessed remotely only for Google Chrome. We don't have the local data from his computers, hard drives, all that, because there were so many tangible items in that house we had no access to. So we don't know if he had a Linux computer, we couldn't have searched it. We only used the master password to access Google. So whatever he did on Google, we were aware of. But local hard drives and things, we had no access because we were not given that as part of the estate. It was taken by Marianne, by Miss Hilliard, and brought to her own home.
And in terms of you've spent a lot of time in the brief, we haven't even touched on it yet, about the definition of documents.
Yes.
As I understand your argument, you're not saying, you don't disagree that you never asked for hardware. You didn't ask for hardware. You're saying that that was encompassed in the word documents.
Documents and electronically stored information, and she says she has stored our electronic and non-electronic storage locations, but yet in the depositions she said she had possession of all these hard drives she didn't own, had no access to, and so she never searched. So she did not fully complete an appropriate search for deposition, for discovery, sorry. And that, obviously prejudices us. We didn't have access, even though she had no entitlement to it.
It's the position of, as I understand it, it's the position of the employer, Helen of Troy, that your father also designated the plaintiff as a beneficiary of the life insurance in 2017.
Yes.
Right? Shortly after he started work. Is that right?
So the evidence they provided for that was a couple emails back and forth stating the only thing that I'm paraphrasing, the only thing that we have to show that was a picture of an Excel sheet with just his name, Marianne Hilliard as the beneficiary, and no, electronic fingerprinting, and it was an editable Excel sheet. It was a snapshot of Excel.
You're taking,
That was it. That was the entirety of their evidence.
Are you saying then that, so that is evidence that came from a third party, from Helen of Troy, right?
That was the communication between Lena and Helen of Troy, who are both parties in this. Not Helen of Troy, that is true.
So Helen of Troy said, and I assume that this is in the record in some way that is in evidence, in the sense that Helen of Troy was either deposed or wrote a document that says, on some date in 2017, I think sometime in the summer, he designated the plaintiff as beneficiary. Am I right about that?
They stated that was all they knew. Yes. That there was no, and again, we had already stated that we had doubts about the beneficiary designation at that time. And I argue that it was insufficient to show that he was the one to enact that change too. There was no way to further support. This is substantial assets.
You have to show somehow that that was fraudulent. Is it a suggestion that Helen of Troy was being fraudulent with you?
No, I don't believe so. I think they're
wrong.
I think they were acting based on online portal information gained from online portals. There is nothing outside of online portals that further supports that he would have made this change. And again, she had access to all these accounts.
So in other words, you're saying she was responding as if it was your father?
Yes, so in their mind, it was our father, but the verification, the authentication of that did not meet standards, which is to both, and even in mass regulations, it said that you need to show at least the standards of security that you used to protect an account. You don't necessarily have to say exactly.
Where is the evidence that the plaintiff was seeking passwords or anything else for your father in the middle of 2017?
I mean, there was a Google that said a Google search that said how to force Google Chrome to save passwords. There was also emails back and forth between Ms. Hilliard and our father that said essentially that my father had left the house angrily because he would not share passwords with her.
2018. I'm asking about 2007. You know, this is the problem that anybody has, which is, you know, is there sufficient evidence, material evidence, from which a jury could find fraud? It seems to me, with respect to Helen of Troy, you have to show it for both the 2017 and the 2019 event. That's why I'm asking you about the 2017 event.
We were unable to complete discovery in this case. We were searching for more information so that we could more clearly understand who changed the beneficiary, but we were thwarted there. Again, we didn't receive IP addresses or timestamps for some of the changes so we could recreate with the Google metadata, which again has not been all that available until 2018. So the case law precedent is going to lag behind that anytime there's technological advances like that. So if you take, you know, the typical security standards of IP address timestamps, and then you also use Google metadata, you have sufficient evidence there potentially to either exclude or include an online portal user authenticating an e-signature. But in this case, we were unable to obtain that information. We were obstructed at every step. So that's why we're here. We wanted to get more information. And summary judgment when that sort of question is not appropriate.
Okay, well, we've gone well over time.
Sorry.
But no, it's important for us to understand your argument, but I think we do, and we got your brief and your reply brief. So we'll hear from the plaintiffs.
Thank you so much for your time.
And just, you know, have a seat at the table and for the remainder of the argument.
Good morning, Justices. May it please the Court. My name is Pamela Pardo, and I represent the appellee, Marian Hilliard. There are two issues properly before this Court today. Whether there is any evidence that Marian Hilliard submitted the designation of beneficiary forms to Life Insurance Company of North America, who are referred to as LINA, in January of 2019, and the designation of beneficiary forms submitted to Fidelity in August of 2019. And the answer to that question is no.
There's no evidence?
No evidence.
How far is it from where the deceased father lived to work?
So it's about 33 minutes without traffic, if you rely on Google.
So there's no evidence? You can't draw an inference from the fact that
There's no, sorry to interrupt, Your Honor.
Yeah, you can't draw an inference from the fact that at 9:21 on a particular day, he's in a box near his home, and at 9:50 is when the thing was changed? Why not?
There's no evidence that Mr. Hilton went to work that day. There's no evidence that Mr. Hilton wasn't a passenger in the car if he did go to work that day. There is nothing to corroborate the statements that was presented by the Hiltons.
We know that 9:50 was the time on January 17th that the designation was changed, right?
I think it was
9:54.
9:54. But what you're saying is we don't know whether he did that from home or from work.
Precisely. Nobody knows. There's no evidence to suggest what Mr. Hilton was doing at that time on that day. He could have been in his home. He could have been at Walmart. He could have been at Dunkin' Donuts. The process of changing the designation of beneficiary form is actually quite straightforward.
Can't we infer that he was going to work from the fact that the Google Maps, and we know, certainly it's in evidence that he used Google Maps to get around at that time of his life, right?
Yes, I believe that that's...
Okay, so can't we infer from the fact that he accessed Google Maps and asked for directions to work? Can't we infer that that's what that's showing?
I think it's showing that he accessed the Google Map to show directions from work, but I'm not convinced he wasn't at work at the time, because we're just relying on the statements of a layperson.
I think I'm reacting to your words, no evidence.
There's no evidence, Your Honor, and I will stay there.
Oh.
I will say this. I got up this morning, before I ever even got out of bed, I accessed Google Maps to find out how long it was going to take me to get to court. It was 6:34. I didn't even think of the case, honestly, until afterwards. Did it mean that I was driving to the courthouse at 6:34? I wish I had. There was no traffic at 6:34.
Although, I mean, don't we have to look at the light in the evidence, in the light most favorable to the non-moving party?
Absolutely you do, but there's nothing in the record that suggests that Mr. Hilton was in the car at the time he accessed that map. There's nothing in the evidence. Well, let me take this a step further, that the Hiltons are precluded from putting forth any expert testimony at either the summary judgment hearing or at trial in this case. The judge ruled on a motion in limine. It's part of the record. It's at page 186 of the supplemental appendix, and this is the type of information that they've been presenting to you is the type of information that I strongly suggest requires expert testimony in this case, and they simply cannot do that. The motion in limine was not appealed, and it's still the law of this case. So with either party not presenting expert testimony, there's simply, again, I will say this, there's no evidence that suggests that Mr. Hilton, that somebody other than Mr. Hilton submitted that designation form.
Do you also have an argument that the presentation they've made in their appellate brief is not what was presented to the judge below?
I'm sorry, I couldn't hear you, Your Honor.
Sorry. Do you also have an argument that the presentation that they've made in their appellate brief is not the argument that was made or presented to the judge below?
Absolutely, Your Honor. There's a tremendous amount of information that's both in their appellate brief as well as in their reply brief that goes way beyond the scope of what was argued below and is therefore waived. I think that as far as the reply brief goes way beyond the scope of anything that was submitted in the appellee's brief. But anything, the issue that the notice of appeal itself only focuses on the fourth motion to compel and the summary judgment motion. Anything beyond that, I suggest, is waived by the appellees.
Why? Aren't they just appealing from the judgment? They have judgment against them. They're appealing from the judgment. Can't they raise any issues that are related to that would overturn the judgment?
Well, evidentiary issues, sure, yeah. I think they can. I mean, I'm just pointing that out, is that the one thing that they did not appeal is the motion in limine. But in the way they structured the appellant brief, they effectively appealed just about every other order that this judge made. And even still, it doesn't get them over the hurdle of producing evidence in this case. The map, which we'll focus on because that was part of the underlying case, they were represented by counsel at the lower court. And counsel reported to the trial court that this was a step-by-step showing of where Mr. Hilton was on that day. And I think if you read the judge's decision, memorandum of decision, she certainly controverts that. She says clearly that is not what was
They
the
just
case.
controverted that. They said, no, what this shows is where he was at a particular time. That's the snapshot. They seem to be right about that, don't they?
I'm not sure that they are right about it, but even if what they say is accurate and Mr. Hilton was somewhere around his house at 9:21 in the morning, there's no other supporting evidence to say what he was doing. There's nobody at the work that said he was at work that day. We don't know where Mr. Hilton was that day. And to ascribe him a location because on a Google map, which he brought up a mile from his house at 9:21, I don't think that qualifies to suggest that he could not have submitted the designation of beneficiary form.
What about the argument that they were improperly precluded from getting discovery?
So the Hiltons did not ask for computer-related materials. There were 4 motions to compel that were brought and argued.
And they didn't ask for tangible objects.
They didn't ask for tangible discovery. If you go through what happened in this case, the initial motion to compel was filed, and the court appointed a special master to review the discovery and to report back. And it stated clearly in the decision that all discovery issues were to be brought to the discovery master in the first instance. The discovery master took documents that we presented to her, which included the motion to compel, the opposition to the motion to compel, the interrogatories, the answers to the interrogatories, the document production, and the documents that were produced. And she went through those line by line. And if you read her first decision that was submitted in December of 2022, it clearly outlines that she read through every single discovery request and every single interrogatory request because she, line item by line item, responded to them. And in request number 1 and request number 5, the Hiltons argued that they effectively demanded that Ms. Hilliard produce computers, DVDs, some other electronic equipment. And the discovery master made it very clear at that point in that decision that the Hiltons were not entitled to these articles, these items, because they did not ask for them. That was in December of 2022. Discovery did not close until February 7th of 2023. They had an opportunity to do additional discovery. They were represented by adequate counsel at the lower court level. They didn't do that.
So they file a motion with the special master, or a motion to compel is before the special master, asking for all those computer data and so forth. Discovery is still open at that point.
Discovery is still open at that point.
So your argument is, even though they filed a motion to compel that, they should have filed a subsequent motion for discovery specifically asking for what they were saying should have been compelled.
Absolutely. They had the time to do it. They had a written order that said they didn't ask for this. As a practitioner, I get a request for discovery, and I read it, and I say, well, is this relevant? Is this valid? Is the time frame, appropriate? And I review that. I didn't have the opportunity to do that in this case because there was no request ever made.
Judge's order is from December of 2022?
I'm sorry, say that.
Judge's order denying the the tangible computer stuff is from December of 2022? Is that what you're saying?
That was a special master in December of 2022.
Yeah, I'm sorry, the special master's ruling.
Yes, yeah.
December 2022?
Yes. And then
And discovery didn't close until?
discovery didn't close until February 7th, or I'm sorry, February 2nd, 2023.
But that's because it was extended.
No, it was not extended at that point. The only reason why it was extended was because the defendant, Hiltons, did not provide Ms. Hilton, in my request, with information that we'd requested. So it was only held open at that point for them to respond by providing documents and interrogatory answers to me.
So what happened is the special master issues this order, and he has a whole lot of these things. Please provide an offer of proof as to why this is relevant, why you need this, and your position is the Hilton's counsel just blew that off, right? Never did the offer of proof that was requested by the special master, instead went directly to the judge and said, hey, Judge, they're making a mistake. By the time the judge gets it, it's now closed, right?
Well, yeah, I mean, enough time went by. So the discovery master decision was in December 27th of 2022. And the discovery closed February 2nd. In the interim, there was exchanges back and forth, and it is part of the record, trying to schedule a deposition And so that was an issue as well. And the discovery master testified at these motion to compel hearings, and several of them. And in her own words, she says, "Look, I went through these exhibits line by line. As a result of that, I take the discovery very seriously. We responded to discovery very seriously. This discovery master, who is completely neutral, determined that my client did not have to provide any further documentation because she satisfied the discovery request. She did not have to supplement any interrogatories because
that's where I'm trying to get the abuse of discretion standard. So the special master says, you didn't ask for this. If you want to ask for it, file a motion or file something with me and give me offers of proof, okay? Instead of doing that, they go directly to the judge and file the motion for discovery.
Motion to compel discovery, yes.
Okay? What's the judge's order from those motions?
She denied those motions. She denied the second motion, she denied the renewed motion, and then after...
When she denied them, was that after a hearing at which the special master testified?
It was, yes. And not only that is she did allow them the deposition, even though discovery had closed, and the deposition was held, I believe it was March 23rd of 2023.
This was of your client, right?
I'm sorry?
This was of your client.
Of my client, yeah.
So I want to ask something about that they raised, that your client said she couldn't access their father's devices, she didn't know the passwords, except for one. But on the other hand, so if she didn't, how could she do diligent search to find those records?
Well, it's not her computer, so I'm not sure I understand your question.
So you're saying, well, you think your answer is that she had no obligation to search the father's computers for documents?
Well, at that time, just so you know, the Hiltons forced my client out of the house. It was a 2,000 square foot house. She moved to a 10 by 12-ish bedroom in somebody else's home. Anything that wasn't clothes or her tablet, most of her stuff went into storage at that time. So, and she had health issues, and so...
So are you saying that they had access to the computer that they're trying to compel?
No, it was in a storage container that my client had ordered. She moved all her stuff from the house that she lived in for 15 years with Mr. Hilton.
Her stuff or her stuff plus her former roommate stuff as well?
It was packed up. She moved, it was more than a roommate, it was her life partner. I suggest that you review the obituary.
I'm sorry. I wasn't trying to say anything about that. I just started to say husband, realized that was the wrong word. That's all. Okay?
Okay.
So she didn't have to search those things. Which one is it?
Well, I think it's all the above. I don't know that she had an obligation to search his computer. I don't think she was in a position to search it. I think that arguably it was beyond her ability at that point because she did have medical issues. And then the other substantive issue.
Who could search it? I'm doing a follow-up to Judge Massing. They want the stuff that's in the computer. It's almost like a bait and switch here. She says, I don't have access to it. It's in storage. But they can't get it because she's the one that put it in storage. So how are they supposed to get it?
I think they're supposed to ask for it, and I don't think they did ask for it. And
that's that's back to the special master again.
I think that, and the other part of that is a substantive issue, is what is this, this computer hard drive actually going to show? It's going to show, at best, that somebody accessed it and maybe submitted beneficiary designations to Lena and Fidelity, but it's not going to show who made those designations. It's not going to show who made those designations, and there is no evidence in this
But there could be circumstantial evidence surrounding if that, and again, we don't know, that's part of the problem. If at 9/27 this beneficiary form is changed, and at 9/26 there's a search done that you could identify it was done by him, that's circumstantial evidence that he's the one that changed it, as opposed to if at 1 minute before then, there's a search done of something that might be affiliated with your client, that's circumstantial evidence to say she was sitting at the computer, she did this search, and maybe she filled out the form. I'm not foreclosing, I'm not saying that should have been done, but there could be circumstantial evidence that they could have used. We just don't know.
Well, I think that even if that's the case, that anything that they were to glean off these computers, an expert opinion would be necessary in order to present that to the court. Mr. Hilton is not an expert. I know nothing about his background, and so anything that's in the reply brief that refers to this Google map and where it was or anything else, I think is way beyond the scope of lay opinion.
Well, he may be an expert, but you're saying that there was an expert disclosure and no expert was disclosed on their side, right?
Right, and it was raised with the discovery master. Again, it's in the materials where I submitted expert interrogatories. They were not responded to.
Got it.
And so, again, the process of discovery, it's a real process. It's meant to move the case forward. And this case went forward. And things were not done in a timely manner. I don't know whether it was a strategy. It's not my job to determine strategy, but maybe it was strategy. And now is the 11th hour, they come back and say, well, that didn't work. Let's have another shot of this. We had 4 hearings in front of Judge Monks. In the last hearing, it's in the transcript, she said, we'll trudge through this. We'll get through it. We'll get to the bottom of it. We'll figure out what this means. And after hearing from myself, Attorney Cosentino, and the discovery master, she again, for the 4th time, denied their right to have this. She didn't give an explanation as to why, so we don't know. But certainly the cumulative effect of 4 denials suggests that she understood what was happening. She made her rulings based on what was presented to her in both in written form and at the testimony.
I understand your client has since died, is that correct?
Yes, that's correct.
And so I also assume there's never been any payment of the money. It's being held by the third parties involved?
That's correct. Lena and Fidelity have basically frozen those funds. They're in the market, so they're subject to market conditions, at least not the insurance policy, but the Fidelity.
Okay. And there's now been a substituted person in to be the representative for your client's estate?
That's
Is that correct?
Yeah.
Okay.
In terms of just real quick, I think this is the last question, the 2017 change of beneficiary of the life insurance policy, there's some information that you have about it. There are emails from New York Life in the record, and and I think in your supplemental records. Is that all there is on that?
Yeah, I'll point you to the record. It's page 164 to 173. That's the emails between Alyssa Moore from Lena and Armanda.
Is that in your supplemental?
It is it's in the main
Volume?
volume number 1.
Okay.
Sorry. And also in volume number 1 at 180 to 183, and then at 185 to 187 in volume 1. And there are some other references.
2017 transaction.
This is a 2017 transaction. Yeah, there was a change to the Workday platform in January of 2019, and so they were struggling to get access to documentation prior to that. But these are documents that were obtained through Keeper of the Record subpoenas from Lena, and so they come from that source.
What is Lena?
Lena is the life insurance company of North America. Sorry.
Oh, okay. So these are interesting.
New York Life, Lena,
So it
Cigna.
didn't come from Helen of Troy. It came from the life insurance company itself.
The communications were between Life Insurance Company and Helen of Troy. Life Insurance Company of North America, Lena, was trying to figure out who the proper beneficiary was. I think if you go through the appendix, it also says there's a letter from Lena to Attorney Cosentino saying that they've determined that their clients are not proper beneficiaries of the life insurance policy. And so the issue is that prior to 2019, that Mr. Hilton made Marianne Hilliard the designated beneficiary of that life insurance policy.
Within about a month of starting work in 2017.
Within a month of starting work. So
that is in records that come from Lena.
It's in records that come directly from Lena. Yep.
And it's in evidence that they would confirm that designation both by email and in writing?
I don't believe that that's in evidence. I think that what was happening was they were trying to figure out who was designated and when, and there was an email exchange between.
What I mean is this, and the answer may be, I don't know, or no, or yes. In 2017, there's a Lena says, your client is designated as the beneficiary of the life insurance. Is it in the record that that change in 2017 was notified back to their father, and how was it done?
I don't know if Mr. Hilton knew it, but I will say that the date of that spreadsheet is 2018. So it's prior to the 2019 transactions.
Okay. Well, thank you very much, both of you, all parties. It's a complicated case, and it's submitted. And that will end our session for today. I want to thank the court officers and the clerks, and we'll be in recess.
Thank you very much.